Your Lordship had this matter earlier at length.
Yes.
Here, I want to raise two preliminary objections in the matter, my lord.
This is with regard to that madrasa.
Yes, madrasa.
May I please, Your Lordship? My senior is actually out of town and he has not prepared the case. Therefore, kindly fix the matter after 2 weeks.
What do you mean out of town? I have prepared.
And they have no legal right also to file this petition, my lord, because they have not applied for and they are also not qualified under the 17 Act, my lord, for such provisionalization. Since they have two these drawbacks, my lord, unnecessarily they are flogging a dead horse, my lord.
Yes, who is for the government? Mr. G. Pegu was supposed to bring the records.
My lord, kindly please come over, my lord. On last occasion,
Where is the records? Have you got the records with you?
record was actually, my lord, September.
Huh?
Actually, my lord, on last occasion, was that was 6 on 20. So record was come, but they returned. Kindly please come over, my lord.
Yes, when is Mr. Mahmood coming?
Next week, Your Lordship.
Next week. Where is he gone?
Sir, he is going to Bongaigaon.
Bongaigaon. Next week I won't be here.
I also thought so, since you're not today.
Today is
40.
okay, we'll fix it on April 3rd. But you be prepared on that day.
Sure,
You bring it on 3rd, right?
Much obliged.
On the adjournment prayer has been made on behalf of Mr. M.U. Mahmood, learned counsel for the petitioner. Mr.
G. Pegu.
Mr. G. Pegu, learned counsel for the respondent, submits that he will bring the records on the next date in terms of the order dated 30/01/2023. Mr. A. Chaliha, DP Chaliha, learned senior counsel, appears for the response number 7 and 8.
7 and 8.
On the prayer of the counsel for the parties, list the matter on 3-4.
Much obliged.
May it please your lordship. Firstly, my lord, I tender my sincere apology to filing an inadvertently error my affidavit, my lord, in the writ petition, my lord. It may be, my lord, not as a master role worker, but I have put as a master role worker in my affidavit in the writ petition. So, my lord, kindly be interfered the order dated 16/9/2020.
Why?
My lord, petitioner in their writ petition, my lord, they have admitted that he has been engaged as a work wage basis employee, my lord.
Wage basis employee.
Yes, my lord. Wage in Galabin
So?
IWD project, my lord.
So,
So he is not a master role worker.
okay, but okay, even if he's not a master role worker,
Yes, my lord.
what about the para 22 of the order passed in WA 44,
My lord,
45?
that is, my lord. Yes, my lord.
What does it say? It says master role work charge and similarly placed employees.
Yes, my lord.
So similarly placed employees would include these daily wage workers or not?
Yes, my lord.
If it includes, then what is the
Or only, my lord, in my record, my lord, only my that if he is not a master role worker, that should be, my lord, interfered.
Huh?
Because I have in my affidavit, my lord, I have written as he is a master role worker from 1/8/2002, my lord, but he is not a master role worker.
okay? He's not a
Only-
master role worker.
Yes, my lord. He is working as a my lord on project basis, my lord. Integrated water development project, my lord.
Working as what? On project
As a
basis? What do you
typist.
mean? What do you mean? Is he a work charge worker? Is
No,
he
no, not
a
work.
casual worker? Is he a daily wage? What is he?
He is a casual, my lord, as a typist, my lord,
Casual.
casual.
Casual meaning he works every day.
every day, my lord, and my
Every
lord,
day for the last more than 10 years.
yes, my lord, but my lord, kindly peruse, my lord, page, my lord, page 48, my lord, in my review petition.
Page 48. Page 48, yes.
Yes, my lord. Here, my lord, Director Soil Conservation allowed him as a wage basis temporarily under Dhonsiri FPR scheme of Golaghat.
So as on a daily wage basis.
Yes, my lord.
So he's working as a daily wage worker.
Yes, my lord.
Now, as a stenographer or
As
typist,
a typist, my lord.
typist.
Yes.
Now you in your affidavit, you have mistakenly referred to him as MR worker.
Yes, my lord.
So you want that corrected.
Yes, my
Now,
lord.
how will that change the judgment or the order pass?
My lord, because in the judgment itself reflects that he's a master role worker. So he's
Naturally, you have said in your affidavit, you have said
that
the
was
master role worker.
I, my lord, that is why I'm apologize for my mistake, my lord. And my lord, it only my lord lordship may correct that he's not a master role worker. He is a my lord.
So you have got no grievance with the impugned order, except to the extent that he's referred to as a master role worker.
Yes, man.
Is it?
Yes, my lord.
And is it your case that even if he is a daily wage worker, the judgment passed by the division bench in WA 45
Yes.
would still cover this case?
My lord, yes, it will cover, but he is not a master role worker.
Okay, that we can clarify.
Yes.
But I think maybe we'll have to issue notice, I think.
Yes.
No? Otherwise,
Yes.
let us see what they have got.
Caveat has been filed, my lord. Their name has been shown, my lord, other side.
Have to issue notice.
Okay.
Have you given them a copy of the
Yes, my lord.
review
Yes,
petition?
yes, my lord. I have given.
But they need material instructions, I guess, so we'll have to wait. Heard, Miss
RS Dury, my lord.
R.S. Jury, learned counsel for the applicant who submits that the impugned order dated 16/9/22 passed in WPC 5290/2020 needs to be interfered with, in view of the fact that the writ petitioner has been referred to as a master role worker, on the basis of the review petitioner having referred to the writ petitioner as a master role worker. Full stop. She submits that the mistake has been made on the part of the review petitioner, as the writ petitioner is actually a daily wage worker and not a master role worker. Full stop. She accordingly prays that a correction be made in the impugned order by referring to the writ petitioner as a daily wage worker and not a master role worker. Full stop. She further submits that the correction sought for by the review petitioner would not affect the direction passed in the impugned order for providing the minimum scale of pay. Correct? Minimum scale of pay, even if the writ petitioner is referred to as a daily wage worker. Full stop. Issue notice returnable in 4 weeks. Review petitioner will take steps for service of notice upon the respondent by registered post with AD within 2 days. List the matter after 4 weeks. Okay,
obliged.
but you are sure, correct, that it will not affect. Look, I hope you know what your,
Yes, my lord, yes.
the order that we have passed. Because I can do it now also, but just being careful what your next, your stance may be in the next date.
Yes, my
I am issuing notice.
So to mention item number 16,
Yes,
hearing matter, not sure this, I've been handed over this brief just a few days back. That is why yesterday I also submitted the mention letter for adjournment after 2 weeks.
yes,
Taken
right.
the
Paper book is not ready as
Paper
of.
book is also
Paper
required.
book not ready.
No,
Few matters are listed where paper books are not ready.
Okay, Miss D. Borgohain, learned counsel for the appellant, prays for adjournment on the ground that she has been handed over the brief just a few days back. Full stop. Ms. S. Jahan, additional PP, submits that paper book has not been prepared till date. Full stop. Ms. Para, on considering the prayer of the parties and keeping in view the fact that a prior adjournment request had been made, which has been which has been signed by the additional PP. The matter be listed after preparation of the paper book.
No.
This case was case 8, my lord.
Ah,
8.
8
Item 8, my lord. That is also paper book is not ready.
paper book not ready.
It is not shown as series, but it is not series. 7, 8, 9, 10, and 11 are shown as series, but it is separate cases.
8 is separate.
Separate. It is only 2 accused are there. I have appeared here for both the accused.
So 7,
Paper book,
it should be 7, 9, 10, 11 according to you.
Separate.
Just give us this 8.
8 is separate.
No, you're appearing in which case?
8, my lord.
Yeah.
Oh. Has been directly segregated. So no paper book is there. Okay, right. Heard, Mr.
Alam, A. Alam.
Huh?
A. Alam.
A. Alam, learned counsel for the appellant, who submits that despite the order dated 7/3/22 passed in this case, this item 8, item 8, the case has not been segregated from the other criminal appeals. Full stop. He further submits that no paper book has been prepared till date. Full stop. Has the records arrived?
My lord.
Has the records, where the record? There's nothing to show that the records have been called for also. No, the records have been called for, but has it arrived? Item 8. Huh?
Perhaps that record pertains to the other
Huh?
appeals.
166. It is yes. Okay, right. As LCR has arrived, registry to prepare the paper book.
LCR is in respect of this, I have not checked.
166.
But,
166. It's
Achha.
in 166.
Achha.
Registry to prepare the paper book. This is the matter after preparation of the paper book, and by segregating the present case from the other criminal appeals.
this is in respect of Mintu Rahman and his petitioner's name is Abdul Rahman.
Huh? Just a minute. Huh? Yes, what?
As far as item 8 is concerned,
Yes.
this is not the LCR pertaining to 8.
It has written 166, no, in the
Then the
cover.
petitioner's name is different. Criminal appeal 166.
No, there are two, Abdul Rahman and another. There'll be another person.
Acha, acha. Mintu Rahman.
Huh?
Mintu Rahman and others.
Abdurrahman
Abdul Rahman and Jumma.
Abdul Rahman,
Elias
Safiur
Jumma.
Rahman and Tabidar.
Yes, yes,
Tabibar
yes.
Rahman.
I stand corrected. Jumma is also there.
Yeah, please, Your Lordship. Sir, recommends item number 5, my lord.
Item 5, yes.
It's going to be adjourned for a week, my lord.
Why?
We have already, there is a difficulties in part of it, Mr. P.K. Das, my lord.
Huh?
Mr. P.K. Das.
What about him?
He's not well, my lord.
He's not well.
Yes, my lord.
You see, it has been time and again you have adjourned the matter.
Yes, my lord.
It's not the first time or the second time. It is a habit.
Lordship, we are newly engaged in this case, my lord.
Maybe you might be newly engaged, but then it doesn't mean that you have got to, a newly engaged counsel has to adjourn his matter. It's supposed to be an exception, not a rule. What? What? Yes. You will give it a second copy.
Lordship,
You argue the matter.
only 1 week adjournment may be given, my lord.
Are they on bail?
Yes.
They are on bail.
No, they are inside the jail, my
Okay, right. Who is not well?
lord. Mr. P.K. Das, my lord.
PK Das.
Yes.
Right. Adjournment prayer has been made on behalf of Mr. PK Das, counsel for the appellant. What about item 6?
6 also after week you'll also take up. Same analogous. judgment.
Full stop. Mr. What is your name? Huh?
D. Talukdar.
Mr. D. Talukdar, counsel for the appellant in criminal appeal 187/2017, also prays for adjournment. Full stop. Ms. S. Jahan, addition PP appears for the state. As a prior adjournment request had already been made in respect of criminal appeal 91 of 2017, which has been tagged along with criminal appeal 187/2017. The prayer of the counsels for the appellant is allowed. Let's the matter after a week.
Much.
May I please, Your Lordship? Your Lordship, I pray to mention item number 12, Your Lordship. We have received the cost for the preparation of the paper book. But Your Lordship, the appellant is in jail and we don't have any communication with his mother, Your Lordship.
So
She's in a remote village. We have also mentioned it in the I.
he's in jail or he's in a remote village? Where is he?
He is in jail. His mother is in a remote village. We don't have any communication with her, Your Lordship.
So what is to be done?
Your Lordship, we pray the appellant may be provided with a paper book free of cost, Your Lordship.
The paper book is sent to the Lordship.
How big is it? How thick is it? Paper book has to be free of cost.
We don't have any communication with his mother, Your Lordship.
And how are you appearing free of cost? Are you getting material instructions or you're doing it pro bono? Huh? Let us see the file. Oh, it's very thick. That's my cost. I don't want to pay that cost. You pay the cost, madam. What is this?
He's in jail, Your Lordship. The appellant is in jail.
How are you? Are you amicus?
No, Your Lordship.
Legal aid counsel? No. Pro bono? No. So you don't mind taking the fees, but you can't pay for the cost.
Lordship, last time we communicated, she communicated with the advocate and asked him to take all the actions. Your Lordship.
How many
We have
pages?
mentioned it in
How
the
many pages is this? 289. To deposit the funds.
Deposit the order is in.
I don't, we have already, there is a order to deposit the cost. It is here. What is to be done in these circumstances?
Lordship, let me put it plain and simple, Lordship. In fact, Lordship, the council preparing for the appellate, Lordship has informed me his near relative has expired.
Okay,
I do not know why it has not come from her. His near relative has expired, Lordship, and he is in Dhubri. So therefore, I was led to know that a prayer will be made for an adjournment for 2 weeks.
yes.
So since that was the prayer I had,
But now she's on a different line altogether. And I remember Mr. B. Prasad, yesterday we had adjourned 3 matters because his brother had died last week,
yes,
on 7th, I believe.
yes, Lordship.
And now, of course, that is, see, we also remember what happens one day before. You pay the cost within a week. Right. It has been stated at the bar that there has been a death in the family of Mr. B. Prasad, the learned counsel for the appellants. Appellant. Accordingly, the matter is adjourned for 2 weeks. Acha, before that, you write, Mr. R.K.D. Chaudhary, Deputy SGI, submits that he has got no objection to the prayer for adjournment. Accordingly, leave this matter after 2 weeks. Next para. As the cost for the paper book has not been paid by the appellant, in terms of the order dated 29/6/22, the appellant is directed to pay the cost within a week.
Please, Your Lordship. Lordship, I made the mention for listing of one appeal, Lordship. It was
Huh?
filed, listing of one appeal, Lordship.
What do you want?
Appeal for listing, Lordship.
For listing.
Lordship. It was filed on Lordship 21/2023, Lordship. And
New case,
Lordship, new case, Lordship, for withdrawal, Lordship.
withdrawal.
Lordship, for withdrawal, Lordship.
Why?
Lordship, we have received an instruction from our client, Lordship.
To withdraw.
Lordship. We have filed appeal against Lordship order or rejection order of bail, Lordship, by NIA court, Lordship.
No.
Lordship. For more, Lordship.
How long? This is the order, yes. Yes, this is the last order.
Lordship, I heard this matter at length.
Yes. So it has been listed. So we'll pass the order on the on the.
Prayer for bail is rejected.
Obliged.
Item
Which case
one,
I was
he had filed his objection to the delay condonation. application.
78 days,
That is, and there is an, in fact,
78 days. what
in
is it?
fact, a PIL is pending with the same subject matter.
No, anyway,
and the
78 days
honorable-
will allow. Yes, anything to say?
Yes, ma'am.
Yes, what is it?
Let the petition come on record, my lord. She has sought for a time today not to hear. That's why I sent back the file.
No, I did not get the copy of the objection, so I was thinking that I'll take some.
It's
1 or 2
78 days,
days.
Mr. Council, what is there? There is nothing great. You can give your objection, we'll hear you.
I had
We
sent
don't
back
need
the
to-
file because the request was made.
Oh, you have
She-
sent
she-
back the file.
She said that she'd not be doing the matter today, taking time. So I had sent it back today.
I did not, I could not, I was
We'll
not
give you
here.
my copy. What is there?
Basically, no, basically-
What is your,
basically-
your objection is
No, basically, my objection is on the vagueness of the petition which has been filed.
vagueness.
Vagueness, number one. Number two, the grounds, my lord, which has been put forward for, my lord, this condonation of delay has been dealt with very succinctly by the, my lord, Supreme Court in the case of the Postmaster General, my lord. And thereafter, my lord, the Postmaster General was, my lord, relied upon in later cases. And in those type of cases, my lord, the Honorable Supreme Court, my lord, declined to interfere and condone the delay, my lord.
That's all.
So basically, that was, my lord, the grounds, and I would have like to, my lord, put that and, my lord, argue before your lordship, my lord, for condoning, my lord. That because even the delay is not 78 days, it is around 250 days of delay.
250 days. Day after tomorrow,
A lot.
day after tomorrow.
And in fact, there is a PIL pending, and there the Honorable Division Bench had ordered that, in fact, they had initially observed why the appeal was not filed. And then we had filed the
Can
appeal.
it be the filing in that, as against that also I have replied that that is a controversial
And it-
event in a PIL, my lord, which is pending for some other reason.
In that
Can this
PIL, my
court
lord,
make
I
a
was
minor observation
Just a
that why my lord appeal has not been filed, my lord? Can this court direct the state to file, my lord, appeal, my lord?
No, no,
Or is it something
we're
like
not on that.
submissions or something
We are
which
not,
hearing
we're
for the
we're
first
not
time,
on
my
that. Mr. Council, we're not on that.
Well, just to assist your lordship, my lord, that PIL has already been disposed of because I was an intervener in that PIL as a, for the support person of the child victim, my lord. The order I've already sent it to your lordship's court master. In fact, amongst the observation, one of the observation of the learned division bench is for the state to pursue the appeal in accordance with law.
Yes.
I have already given a copy.
Where
to
where
your
is the
lordship.
order?
They can take a print,
is not-
they can take out a print. Oh, no, okay, print this out. Oh,
No, we've mailed it.
mailed it.
So that is otherwise disposed of. So that is why I just corrected.
I thought it's pending. It's disposed of. In fact, the observation is the state will pursue the appeal in accordance with law. That sentence is there. And I have given my reasons in paragraph 14 of the,
No, he says that he sent back the file, that's all. So we'll list it day after tomorrow, okay?
also you can see the order once.
Let us see the order.
PIL.
My lord, may I also have a copy of the order, my lord?
I can,
Let me first have it.
I can give him, I can give him. Printed out there? Oh, it has not been successfully, it's not made. Acha.
So you want it day after tomorrow? Or we can do it now also, what is that? Basically you have said all you want to say.
But then, my lord, I'll say something more, my lord, let the matter be there, my lord.
Your written objection was filed when?
Yesterday, my lord.
And that's why it's not on the record.
On It's not a recorder.
One more copy for madam.
My lord, one more copy for me too.
You give one copy for the council.
Yeah, it's all right.
Paragraph 4 is the direction.
So this is against acquittal, correct?
This is against secretary. I filed it.
What about your leave to appeal?
After it is condoned, then leave petition lordship will take up. It's now pending.
Okay, right. Miss S. Jahan, learned addition, PP submitted. There is a delay of 78 days in filing the appeal against acquittal. Mr. G. Chowdhury, the learned counsel for the respondent number 1 and 2, submits that he has not brought the file with him today. Has submitted that he has sent back the file as the additional PP had stated that, or had stated that the matter would not be heard today.
She would seek them sometime.
As
I got
she
the
would
copy
be
today,
seeking
yeah.
some time.
Mm.
As she would be seeking some time. Mr. G. Chowdhury also submits that written objection has been filed. Full stop. As the written objection of the respondents number 1 and 2 is not on record, registry to place the same on record. List the matter. Day after tomorrow.
No.
Thursday.
Day after tomorrow will be 16th.
Yes.
16th.
16. The IDs of March will be over. my lord.
Huh?
The IDs of March will be over, my lord.
Please, Lord. Lordship, in this connected appeal, I sitting there.
Lordship, this I has come up for the first time. If your lordship permits me, then I'll file my objection.
Is it
Otherwise,
required?
the
Let us see what is the requirement of filing a written objection. Unless,
Lordship, so I am submitting if your lordship permits.
let
me.
us see, let us see whether
Yes.
it deserves to be given
Considered
due
for-
consideration.
Yes,
Because unless there's a likelihood of being given bail,
yes.
there is no requirement of filing a written objection.
Lordship,
Yes,
Lordship, that
this is a 376 one.
Lordship, live streaming.
No, no, 376.
Live
not
stream-
POCSO.
Live streaming is stopped.
Oh, okay. Live streaming is.
Appeal, I have been appointed as an amicus curiae, my lord. This is against the judgment and order dated 28/4/17 passed by the additional session judge Gwalpara. Wife cutting the neck and neck with a dowel.
302.
302. Wife cutting the husband. But, the facts are like this, my lord.
Wife cutting the neck,
Cutting the neck of the accused. This is
the
the
neck of husband.
husband. Date of occurrence is 21/12/15.
Wait, just a minute. 21, 12,
15
15. What time?
at night.
Night, what time? Approximately?
Approximately, I think it should be something about 12, but I'll indicate the exact time. my lord. It is at around night, but the information was on the next date at about 8:05. What has happened, my lord? The case of the prosecution was that the wife went to the police station and surrendered herself.
Okay.
This is the case of the prosecution, and on
Oh.
that basis, the police informed everyone that the wife has cut the husband. There are no eyewitnesses as such. In fact, this had come before the Honorable Court on 21st of August 2019, when I had argued, and on that date, because there has been no eyewitness, and there were two witnesses in front of,
FIR is dated?
22/12.
well, FIR is dated 22/12/15. By PW1, that is the brother of the deceased.
FIR, that is at page 3.
Page 3. PW1.
Brother of deceased.
PW1.
While he was sleeping.
Yes, my lord. While sleeping. In fact, my lord, before I go back to the evidence, I was just wanting to point out the order of this honorable court that is of 21/8/19. On since the case rests only on eyewitness, since there was no eyewitnesses or any materials, because the wife explains the situation in which she had come to the police station to inform, and then she was wrongly implicated. That is her version in the 313. However, the police says that when she had surrendered and confessed, there were two witnesses. Those two witnesses in the first time was not brought into evidence. Therefore, this honorable
Were there among the list of witnesses?
Yes, yes, they were there. That is why by order dated 21/8/19, the matter was remanded back, my lord. For these two particular witnesses, also, there was two children of the accused and the deceased. One was 13 years. So the court also wanted his evidence to come on record. Accordingly, this was done. Sadly, nothing has come. In fact, the version of the wife that she was in her mother's house somewhat stands proof, because the child says that he was not there in the house and somewhere else.
Who
And
was not there in the house?
the wife said that on that day she was with her mother. She was not in this house, the husband's house. And the children also says that they were not there that
Then
night.
how come she lands up in the police
In the
station?
morning she comes. She explains that situation in her 313, that she had come in the morning when she saw her husband died. Then she immediately goes to the police station.
What time was it in the morning?
Around 8, something like that. She had come in the morning. That was anyway. And the two
Okay, no, just one thing.
my lord.
You said that the case was remanded back to
My
the
lord,
trial court
my
by
lord.
this court.
Yes, yes. By order dated 21/8/19.
Okay, then let us get the facts clear.
Yes.
So the order of the trial court was passed, that when order was passed when?
28/4/17. Page 39.
28/4/17.
Yes, at page 39.
839. Where it was whereby the wife was
Additional Session
convicted.
Judge Gwalpara.
Convicted.
Yes, yes, convicted.
Convicted under 302.
Yes.
Then what was the appeal number?
Criminal Appeal Jail 54/2017.
15/2017.
54.
54/2017.
Yes.
That disposed of on
Not disposed of. On 21/8/19, it was remanded back.
21/8/19. Remanded back.
Remanded in the sense only for the additional evidence. The operating part is like this. In view of the paragraph 18,
Page.
page 5 of that. I think it should be in the front of the lordship's file only, because it's part of the order sheet. This
Page
is
5 of the paper book. No.
no in the order sheet on the file, my lord, because this is the order dated 21/8/19. Has your lordship got it? 21/8/19.
long order.
21,890.
Yes.
Yes, my lord, your lordship will kindly see paragraph 4 first. It's a long order.
Paragraph
I will
4.
not trouble unnecessary. Paragraph 4. Has your lordship got it? We have seen that there is no eyewitness to the incident. The prosecution's case is that the accused went to Bagan police station in the morning of 22/12/15 and surrendered before police, admitting thereby her guilt that she had killed her husband with a dao and that she made the admission in the police station. In the presence of two witnesses, namely Soraram Rabha and Binda Rabha, whose names were reflected as witnesses of the prosecution at serial number 6 and 7, respectively, in the charge sheet filed on 31/1/16. PW 10, the concerned IO of the case, in his evidence also stated that the accused made her statement in the police station in presence of those two witnesses. In spite of that, those two witnesses were not examined by the prosecution. Then paragraph 5, it is seen from the evidence of the informant, brother of the deceased, PW1, that as told to him by police, he lodged the FIR in the case against the accused wife of deceased, his sister-in-law. Paragraph 6, the record of the case also reflects that at the time of the incident, the accused appellant had two children, one son aged about 13 years and a daughter aged about 3 years. The accused appellant in her statement under 313 had categorically stated that in the night of the incident, she was in her paternal home, and when she returned to her house in the morning of the next day, she found her husband lying dead in a pool of blood with cut injuries on his neck with a dao nearby him, and that she had gone to the said police station only to give necessary information about the same to the police. But she was detained by the police. Evidence of the case recorded by the trial court also reveals that police informed the Gaobura and thereafter the local villagers could come to know about the said incident. Then your lordship may kindly come to paragraph 18 at page 5. As your lordship reach paragraph 18. In view of the above, para 18. In view of the above and for the ends of justice, we, in exercise of the power under section 391 CRPC, direct the concerned trial court, Court of Learned Additional Session Judge Walpara, to record the evidence of two named witnesses in the charge sheet, namely Soraram Rava, Binda Rava, as well as the son of the accused appellant, by allowing the defense to cross-examine them. After recording of such evidence, the said court shall certify the evidence of those three witnesses and forward the same along with the case record to the registry of this court. The concerned trial court shall complete the said process within so and so many days. Accordingly, matter was sent back to the trial court for recording the evidence of these three additional witnesses. The same was done and forwarded back to this honorable court. Your lordship will find they have been Soraram Rabha is now PW 12. He admits, my lord, that he does say that she had said, but he also says that she said it while she was in the lockup. So perhaps it's hit by 26 now of the Evidence Act, my lord. And the other one doesn't say that she said anything when he had gone to the police station. And the child, my lord, he's CW1. He says that he doesn't know anything. He was told by his relative that his mother had cut. But he also says that on the night of the occurrence, I wasn't present in my house.
So where was he?
Maybe in the paternal's house. We don't know. Because
How old was the child?
13 at that time.
13-year-old child should be in the house.
But he also says he doesn't say that he was in home or he was in home or his mother. Anyway, but if your lordship allows, I can now place the relevant evidences. PW1
Let us go to the trial court's order.
Before that, just three evidences that we take your lordship through, Mela. Your lordship will kindly have the FIR, which is at page 3. This is dated 22/12/15. Humble submission is that in the night of 21/12/15, my brother so-and-so aged 40 years who reside in the same village was hacked to death with a dao by his wife and accordingly registered the case. Then your lordship will find PW1 at page 7 is the informant. Page 7.
Yeah.
May I have filed this case against my sister-in-law Bijuli Bala Rabha with the allegation that she had murdered my brother, elder brother. The incident has taken place on 21/12/15 at night. On getting your lordship will kindly note this, on getting information over telephone from the police station, I went to the house of my elder brother. My house is situated about so and so from my deceased brother. On reaching home, I saw my elder brother lying dead on the floor and a dove was found nearby the body. Police came. The dead body was taken for conducting postmortem to Goalpara Civil Hospital. After postmortem examination, the dead body was taken home for cremation. In respect of this, I have filed this case. Exhibit 1 is the FIR. Exhibit 1 is my signature. Police also seized a dove. I put my signature on the seizure list. I have seen the dove and a Genji with blood stain of my deceased elder brother in the court today. So and so are the exhibits. Then during cross, if your lordship can see, I myself have not seen who murdered my elder brother and how he died. I only got the information over telephone from the police on the next day of the incident. The houses of so and so, so and so, so and so are situated in between the house of deceased and myself. None of the neighbor could know the incident. I don't know who visited the house of my elder brother at night, and the house of my elder brother is situated at jungle in hilly area. I have seen the dead body of my elder brother lying on the ground, which is used as a bed also. I saw the blood-stained bed sheet. So basically he was sleeping while he was hacked, where my deceased brother was slept at the time of incident, but the bed sheet is not seized by the police. So and so, so and so, so and so, and so and so along with me went to the house of the deceased elder brother, and we see the dead body of my brother. The house of deceased has a bamboo door, and I could not say who first opened the door. The villagers went inside the room by opening the door before my arrival. The dove was stained with blood. I filed this case as told by police against my sister-in-law. PW2 is the headman who also says that the police had informed and accordingly he went. PW2, the headman. I know both the complainant and the accused. I am the government appointed village headman of that place. At about 6:30 a.m. on 22/12/15, the OC sir informed me over phone that Bijuli Bala Rabha had killed her husband and that she was kept at the police station. I was told to inform the relatives of the deceased. Accordingly, I went to Bijuli Bala Rabha's husband, so-and-so's house. The OC opened the door of the house and saw the dead body lying in a pool of blood. I saw a dove lying nearby. I did not go to the thana. I did not witness the accused myself. I did not witness myself as to who killed deceased so-and-so with what. I do not know as to when the incident took place. The OC along with 7 or 8 police personnel arrived at the place of occurrence at about 7:30 a.m. The OC was standing on the so-and-so road along with his staff. Nobody accompanied me. The OC and I saw the door of the house in an open state. Deceased so-and-so is situated in the foothills. The deceased used to consume liquor. I am not aware whether he used to consume liquor with his friends. I do not know who used to visit the deceased house and when. The dead body was lying on the ground. The bed sheet was stained with blood. A dove was lying near the dead body. Police seized the dove and a vest. The lordship will note that the bed sheet was not seized, which had where the dead body was lying. That bed sheet for some reason was not.
Even if it was seized, what would happen?
Anyway, I'm just finding out. I have not seen those in the court today. PW3 is another neighbor. He also says the same thing, house in the hill and jungle, and he has not seen. Towards the third line from the top, your lordship will see. On arrival of police at the place of occurrence, we also left to the house of deceased. They went after the police had gone. The police personnel told us that the accused has committed murder of her husband. We have not entered into the room where the incident has taken place. The police has taken away a dowel and some clothes, and then they put the signatures. In cross, your lordship will see, I don't know who murdered so-and-so and how he died. There are two houses situated in between the house of deceased and myself. The house of deceased is situated at the hill inside the jungle. I have not seen the accused while police came. I have not seen the material exhibits 1 and 2 from where it was taken by the police. I have not stated before the police that the police personnel from the police station informed me that the accused has committed murder. So though he is one of the Caesar witness, but he did not see how and from where and what was seized. That's what he said. But he, however, is one of the witnesses. PW4 again is another Caesar witness. He also says it was not in front of him. The lordship will see about fourth line from the top. After arrival of the police, we came to know about the incident. We are informed by the Gaubura that the incident of murder has taken place in our village and deceased so-and-so is murdered by his wife. Police sees one dowel and some clothes, then those exhibits and signatures. In cross, your lordship will see the third line from bottom. I have not seen from where and how these articles were collected by the police. I have never asked the accused anything about the incident. He is the second Caesar witness who has also not seen. Then PW5. PW5 is another neighbor. Fourth line from the top. The police, I came to know about the incident on arrival of police at the house of deceased. The same thing, then the Caesar list, and during cross, police has recovered the exhibits from the place where the murder has taken place. At first, the police has entered into the room where murder has taken place and recovered so and so. However, he doesn't say whether he saw, he didn't say. This he doesn't say. Then PW6, who is again another neighbor. Fourth line from the top. We came on the next third line, sorry. On the next day of incident at about 9 AM, we come to know about the incident from the police station. That accused so-and-so went to the police station after murdering her husband. We have seen the dead body in the house of so-and-so, and then this is basically the inquest witness. In cross, your lordship will see. My house is situated at a distance of half kilometer away from the house of deceased, and there are 5 to 7 houses in between our house. I have not seen who murdered the deceased and how he died. I have heard the incident from so-and-so. I have not come to the police station in respect of this incident. I don't know whereabouts of the accused from the night of the incident till the morning of the next day. So there is one witness who says, I don't know where she was in the night also. She doesn't know. I have only gone to the house of the deceased after arrival of the police. I don't know who opened the door of the house. I, along with so-and-so and 10 other persons, arrived at the place of occurrence after arrival of police. The house of deceased is situated in a jungle, and I have no knowledge who visits the house of deceased at night. The deceased drinks liquor with his friends. I put my signature at the inquest, and this is the context.
So liquor is a big issue.
Liquor, friends.
But unless there is anything to show that he acts violently or doesn't act normally,
Come here,
that has got no relevance.
has not come.
Or he beats up his wife or something.
No, only thing I think in the additional evidence when one person says they quarrel,
PW13.
PW
Says what?
13.
Relationship was not.
They were
cordial.
married for a very long period, but they used to fight regularly as the deceased was a drunkard and used to come home drunk, to which my sister had objected. Only that.
Objected.
This came in the
That
additional.
objected how objected? I mean, verbal fights, physical fights, what? all those-
Evidence, I don't think, my lord, perhaps, my lord, it is for your lordship. As it is, it's a case of a circumstantial evidence. Whether beyond reasonable doubt it is that to be proved, because otherwise there's nothing to show. And 313, she says she was not there. And her son also says he's 13 years, he can't be alone somewhere else.
Could have been tutored.
But when there are two views, then the benefit will always go to the accused, my lord. It's a case of circumstantial evidence. Those are there, of course.
This.
So 7,
We'll come back afterward.
the accused so-and-so surrendered before police station and told them that she has murdered her husband, my elder brother. On the next day morning of the incident, the police from the police station telephoned to our village person and called to the place where murder was committed. I saw my deceased elder brother lying on the ground with severe cut injury on his neck, and a dove was lying nearby the dead body. Police came and the dead body was taken to so-and-so. During cross, my house is situated at a distance of 1 kilometer away from the house of my elder brother. I myself have not seen the incident. My deceased elder brother was living in a house near the hill in a jungle. I was not present with Subin Rabha when police informed him over telephone about the incident. I have not visited the police station where the accused sister-in-law was kept by the police. We came to the place of occurrence after arrival of the police. There was a large gathering. I have not seen who opened the door. The PW9 is the postmortem doctor. There are 3 injuries which your lordship will find towards the end. There is a cut injury right and left lung, then 1 cut injury over the throat, another cut injury over the right side of the neck. Opinion because of these injuries. And during cross, no case number is mentioned in my report. I have not given details of the relatives who identified the dead body. The body arrived at 2:45 p.m. and examined at 3 p.m. on 22nd. I have not described the age or freshness of the injuries. I have not mentioned the weapon used to cause the injuries of the witness. Then PW10, who is the IO, madam? PW10. May I read, madam? That on 22/12/15, I was posted at Bagan Police Station as Sub-Inspector of Assam Police. On that day, at about 8:05 a.m., accused Bijuli Rabha, wife of deceased, surrendered before the police station and informed that on that night at about 12, she herself stabbed her husband inside the house with a dao and killed him. On getting information from her mouth, we made GD entry bearing number 381 dated so-and-so, and on the basis of the GD entry, I, along with party, immediately rushed to the place of occurrence. Accused so-and-so was kept in custody at the police station itself. Exhibit A is the certified copy of the GD entry. I prepared the sketch map. We found the dao at the place of occurrence and a Genji, and both the aforesaid articles are formally seized in presence of witnesses. Exhibit so-and-so, that is relating to the sketch maps and the exhibits. Then your lordship will come to the next paragraph. Witnesses were examined at the police station. The inquest was done by the circle officer of Balijana Revenue Circle, and the dead body was sent for post-mortem examination. The FIR was filed by one so-and-so at police station at about 2:05 p.m. on the same day of incident, actually on the next day. Exhibit 1 is the FIR and Exhibit 1-2 is my signature. The informant was examined at the police station itself. Accused Bijuli Rabha was also interrogated at the police station. 2 more witnesses were examined. The accused was formally arrested at 3 p.m. on the day of occurrence and forwarded to the court for recording her confessional statement. On 23/12/15, I collected the postmortem report. After completion of the investigation, I submitted the charge sheet against the accused and so. Then during cross, your lordship will find Constable so-and-so has prepared the GD entry as per direction of me, and I have not examined him as witness. The person who has conducted the inquest over the dead body, although put his signature, but there was no seal, and the designation of that person mentioned in the inquest report, and the person used his short signature. The inquest was conducted by so-and-so, 1 ASI, 2 constable, and 1 battalion accompanied me to the place of occurrence, but I have not made any one of them as witness. The door of the room of the place of occurrence was half open. We have seized a dao and a blood-stained Genji. I have not mentioned any stain of blood on the seized dao. We entered in the room with so-and-so and so-and-so. I send the seized dao to the forensic laboratory for examination. No report, however, has come. During interrogation of the accused at police station, two persons, namely Sora Rabha and Brinda Rabha, were present. These are the PW 12 and 13, 11 and 12, I'm sorry. I have not seized anything from the place of occurrence such that the floor on which the dead body was lying. I don't have any personal knowledge about the incident, nor I have seen the incident by myself. I have not seized any clothes from the accused surrendered before the police station, and also I have not noticed any blood stain on her clothes at the time of her surrender. It is not a fact that in fact the accused went to the police station to inform. This was put in cross, but he denies. It is not a fact that in fact the accused went to the police station to inform that somebody has murdered her husband, but instead of we implicated her as the murderer of her husband. It is also not a fact that as dictated by me, the complainant has filed the FIR. It is not a fact that I have not investigated the case properly and the accused is charged on suspicion. Then PW 11 is the person who's the doctor who did the inquest, not very relevant, Your Lordship. Huh?
He's an officer who conducted the inquest.
Yes. So Your Lordship may come to the 313 statement that Your Lordship will
So
find.
this was a 164 statement recorded.
It's not there. Your Lordship may kindly come to page 32.
Difficult.
Very difficult. So I said like, I think.
She was telling me before that it's a case of acquittal. I said, God
No,
knows.
Because nothing, my lord, except the confession before the police, not admissible under the law. Nothing.
Because
Lordship, from which place it was recovered, the Caesar was made, nothing is there on record. Nothing.
the only thing which creates a little suspicion is the fact that her going to the police station and surrendering, but that
Only
she
that.
explains in her 3-1.
Yes.
And
She went
to
to
that,
inform.
Your Lordship would recollect there was a case of Dibrugarh where one person landed up in the police station with a severed head. Ultimately, that also went for acquittal because except that, nothing was there. So the Honorable Division Bench says that that only gives a suspicion, but just that conduct itself will not be sufficient to without there being anything else. Because there he explains why he went and how he carried the severed head in her 313, just like our case. I'm carrying that decision because I recollected something like this happened in Borolumuk long back
Yes,
when
yes,
we were in
yes.
school. So I was trying to see if that case I can find, but I couldn't find
No,
that,
no,
but I
is
found
death
this from
sentence,
Dibrugarh.
death sentence.
That
Death
sentence.
sentence.
I found another case of Dibrugarh where it came fit to the division bench that. Anyway, my lord, I'll just show the explanation in 313 and take those additional evidence and then chain gets completed, my lord. The 313 statements Your Lordship will kindly see. The first the answer to question number 2, where she says, I was not there at home on the day of occurrence. I was at my maternal home. So she explains where she was. Then answer to question number 3, I went to the police station upon seeing the dead body of my husband. Afterwards, my brother-in-law went to the police station and said that I had killed my husband. Then question number 4, answer to question number 4, on my return from my mother's house, I found myself in that state. And then at page 34, answer to question number 8. On seeing my husband lying dead, I went to inform the OC at the police station. The next page, answer to question number 12. I do not know. I was in my mother's house on the day of the incident. Then answer to question number 14. On my return from my mother's house, I saw a dao near my husband who was lying on a bed. Then at page 36, answer to question number 17. At page 36. Since my brother-in-law went to the police station and said that I had killed my husband, I was kept in police custody. Then the last answer, that is to question number 19. I have heard that when the members of my family members came to see me, the brothers of the deceased demand money from them, and they even say that they will kill me when I come out of the jail. They have lodged this case on false charge. I did not kill my husband. They have lodged this case against me out of grudge. Now, my lord, that additional evidence that has come,
Now, why would they have, what is the reason for them lodging a false case against you?
my lord, that if your lordship see, the informant himself says that I am only lodging a case against my sister because the police tells me. The informant explains. He says the police tells me that she has killed. So I am lodging. He explains that. He clearly explains, my lord.
At PW1.
PW1. I'll just read that, my lord.
Page 7.
Page 9 also. I filed this case as told by police against my sister-in-law. Page 9, the last sentence. I filed this case as told by police against my sister-in-law. He clearly says that, my lord. Now, from the
Now, why should the police tell a lie?
Lord, there can be so many ifs and buts. my
What
lord.
are they going to gain out of it?
Yes. Just, my lord, if I may just, maybe it's like finishing one case, booking someone, completing the investigation. Huh? My junior was trying to say promotion. There can be a lot of reasons why not we, but anyway, my lord.
But sometimes they do, it's like you're painting the police with a, with a black brush, saying that everything they do is a lie.
No, but in this situation, if your lordship will see the evidences, everyone has said that it is the police who tell them. The police called the
Naturally,
headman
because
she went there.
now when you take it the other way, the appellant has told the police. Now there can be situations where an appellant can tell the truth to the police, and the police is also telling the truth.
There can
And
be-
even the
there
weapon
can
was
be.
sent for FSL, that report is not there.
And
So if the finger
additional
marks were
facts,
there,
it could
would
have
have been
come,
there.
that chain could have been completed. Right now, that there is some incomplete, my lord. To otherwise say that fully it is proved against the accused. Perhaps that chain is not complete. Because we don't know why she was not sent to magistrate.
The
for
law is there,
164.
so what we have to go by.
Your lordship will kindly see PW 12, my lord. PW 12. This is that additional evidences that has come. PW 12 at page 1.
There.
This is Sararam Rabha. I know the informant so-and-so and the accused so-and-so, as well as we all belong to the same village. The accused was the wife of the deceased. They were married for about 15 to 20 years. One morning, we came to know in the village that on the previous night, Randhan Rabha was murdered by the accused with a dowry in their house. And we also got to know that after the occurrence, the accused had voluntarily surrendered before the police station. My house is situated so-and-so from the place of occurrence. I did not witness the occurrence. I had met the accused at Bagan police station, where she had disclosed to me that I have killed my husband. Later on, during investigation, the police had recorded my statement. Now, in cross, if your lordship kindly see, I do not know the exact date, time, and place of the occurrence. I had never visited the place of occurrence till date. I had come to know about the occurrence from our village headman over phone. I had gone to Bagan police station on the next day of the occurrence at about 10 a.m. About 15 to 20 other people from our village had also gone to the police station on that day. I had seen the accused behind lockup at Bagan police station. Today, I do not remember the name of the persons of our village who had gone there on that day. But I remember going near the accused, kept behind the bars and talking to her. The accused had disclosed in front of police that she had killed her husband. So this is clearly hit by section 26 of the Evidence Act because it was in custody and in presence of police. Then the rest, then paragraph, next is PW 13. PW 13 is brother of the deceased. Though the police have said that it was in front of PW 12 and 13, 12 says that in the lockup she does said that. However, 13 doesn't say that part. 13 says the accused so-and-so is my elder sister and the deceased, I'm sorry, he's the brother of the accused. And the deceased so-and-so was her husband. They were married for a very long period, but they used to fight regularly as the deceased was a drunkard and used to come home drunk, to which my sister had objected. The occurrence took place at night about 6 to 7 years ago in the house of my sister. On that night, on the next day morning, we came to know in the village that my sister had killed her husband with a dowel. In Cross, the deceased had many drinking partners and they used to create ruckus near their house at night after getting drunk. I did not witness the occurrence. I do not know as to how Randhan Rabha died. I do not know the name of the person from whose I had come to know about the occurrence. I never visited the place of occurrence after the occurrence had taken place. I have seen my sister today for the first time after the occurrence. Then CW1, the child witness, my lord. At the time of deposition, he is 18. At that time of incident, he was about 13. The accused so-and-so is my mother, and the deceased so-and-so was my father. I do not remember anything about the occurrence as I was very young at the time of the occurrence. But I have heard from my relatives that it was my mother who had killed my father. On the night of the occurrence, I wasn't present in my house. As such, I do not know what happened between my parents. So this is the entire evidence which has come out. Just two decisions, my lord. One is that decision of this honorable court, which I said about that Dibrugarh incident, my lord. This is by Justice Ibo Tombi Singh. This is reported in 1981 Criminal Law Journal 424. Paragraph 2, if I may just place, my lord. The facts of the case giving rise to this appeal may be briefly stated as under. On 5/10/74, the officer in charge of so-and-so station received a telephonic message from Dibrugarh police station that one man appeared at Dibrugarh police station with a severed human head. So this is how a suspicious was built. Then, of course, here there was a confession statement also. Then paragraph 19, if I may just take your lordship. Paragraph 19. The conduct of the accused that he came to the police station at Dibrugarh with the severed head of a human body in a bag is, however, admissible under Section 8 of the Evidence Act. In respect of this evidence, the accused in his statement under Section 313 admitted that he brought the human head of a dead body to the police station, but he stated that he happened to touch the severed head while he was in a state of drunkenness and brought it to the police station. Paragraph 20. The result of our discussion is that except the piece of evidence in regard to the conduct of the accused admissible under Section 8 of the Evidence Act, there is no other evidence to fasten the accused to the offense. In our opinion, this evidence alone is not sufficient to find him guilty of the offense of murder. It may give rise to suspicion, but it cannot be the basis for conviction of the offense of murder. The prosecution has not succeeded to lead evidence to rule out beyond reasonable doubt the possibility of the deceased being killed by someone else. The accused has explained his conduct in his statement under Section 313, as already mentioned. In our view, the circumstances, the accused is entitled to the benefit of doubt and is entitled to the acquitted on that ground. Then there is another decision, your lordship. I don't think I need to place any decision on circumstances of evidence, but just one which I generally always carry, my lord. This is reported in 2009, volume 13, Supreme Court cases at page 740. Paragraph 11 and 12. Read one paragraph, my lord.
Yes,
2009, volume 13, Supreme Court case.
yes, we have got it.
You all should have it. Just paragraph 11, the quoted portion of paragraph 12, which is there in para 11. It has been consistently laid down by this court that where a case rests squarely on circumstantial evidence, the inference of guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of the accused or the guilt of any other person. The circumstances from which an inference as to the guilt of the accused is drawn have to be proved beyond reasonable doubt and have to be shown to be closely connected with the principal fact sought to be inferred from those circumstances. In so and so, it was laid down that where the case depends upon the conclusion drawn from circumstances, the cumulative effect of the circumstances must be such so as to negative the innocence of the accused and bring the offenses home beyond any reasonable doubt. Various other are mentioned. This is from 11, para 12. So, my lord, apart from the fact that she had surrendered, nothing is there to connect her. In fact, in her 313, she says she was not in her house that night. No witness says that she was there. In fact, one witness says, I don't know her whereabouts from the night of that incident. And her son also says that he was not there. He's 13 years. So perhaps he was with his mother in the grandmother's house, grandparents' house. That possibility is also maybe is there. I leave it to your lordship, my lord.
Yes, madam.
Lordship, the prosecution, may I honestly submit before this honorable court?
Huh?
May I respectfully submit before this honorable court, your lordship, the prosecution could not prove the case beyond all reasonable doubt, madam. Only one circumstance that she surrendered in the police station. There is a confessional statement made before the police, which is not admissible part by section 25 of the Evidence Act, madam. There's nothing.
What about any seizure made?
Seizure was made, but from which place it was made? It was lying there, but lordship that the accused identified.
For any FSL?
No, it was
report?
there like, I've seen that it was sent for FSL, her fingerprints were taken, but lordship, nothing is there. No report I have found.
Then how come the trial court convicted?
Lordship,
What was the
see
ground?
judgment,
But
para
they have
60
taken
onwards.
note of the GD entry, which obviously is not evidence. I checked
Let
that.
us see, let us. What is the ground? What
Yes,
is the
para
basis
60
for
onwards, my
conviction?
lord.
Wait, Bharaniba.
Page 59.
Yeah.
There are 60. Now the evidence of all the witnesses from PW 1 to 8 reveal that they have seen the dead body of the deceased Randhan Rava in his house. PW 2 further deposed in his evidence that the police has informed him over telephone by saying that Bijuli Bala Rava has murdered her husband and she has been kept in the police station. Exhibit B, Exhibit D clearly shows that the deep cut injuries suffered by the deceased Randhan Rava on his neck. Those are the photographs of deceased taken by the IO during investigation. The learned counsel for the accused cited in decision so and so. Confession of accused in the police custody while the accused on lockup, she killed the deceased by hacking him with a dao used in the crime has been kept in his house. Therefore, section 27 mere leading to discovery the weapon used to crime, alleged used in commission the offense itself would not suffice requirement of section 27 of the Evidence Act. But a said decision is a misfit as regards the facts and circumstances of this case. It has clearly already been mentioned that the episode of the offense came into light on being surrendered by the accused before the police station. Exhibit C is a photograph of the Garo Dao lying near the dead body, and this has clearly corroborated by the fact that the accused, while surrendering before the police, informed that she has killed her husband, Randhan Rava, by her own hand by hacking with her dao. The Caesar witness, namely PW 1, 3, 4, and 5, clearly proved the seizure of material exhibit 1, the dhow, from the place of occurrence. The learned's defense could not demolish any evidence of these Caesar witnesses. Moreover, all the Caesar witnesses have identified the material exhibit 1 in the court during their recording of evidences. So there is no doubt that material exhibit 1 is the weapon used to commit the offense, and this has been seized from the place of occurrence. And moreover, the accused during her surrender before the police informed that she has killed her husband Randhan Raba by her own hand inside the house with a dhow. Therefore, the chain of circumstances is unbroken. Moreover, Exhibit A, the certified copy of the GD entry, as well as the evidence of PW10 reflects that accused Bijuliwala surrendered before the police station claiming to kill her husband by her own hand with a dhow. And this aspect is enough to connect the accused with the offense, and there is no doubt about the identification of the accused. The GD entry refers to a person who surrendered before the police and informed that she had killed her husband inside her house by hacking with a dhow with her own hand at about 12 o'clock on 21/12/15. There is nothing to show that apart from the present accused, there is also another person who happened to appear before the police station. On the basis of surrender and information given by the accused, her GD entry, the dead body as well as the weapon used to commit the offense are found. Therefore, this very conduct of the accused is relevant under Section 8 of the Evidence Act, which goes against the accused person. Therefore, the conduct of the accused Bijuliwala Rabha itself is evidence of motive for murder, and there is reasonable doubt from other substantial evidences that it is the accused Bijuliwala Rabha who have committed murder. Therefore, it can be concluded that the chain of circumstances is unbroken. The episode of crime came into light after surrender of accused Bijuliwala before police station and informing them that she of her own hand has murdered her husband by hacking with a dhow inside the house. The police discovered a dead body and a dhow used in the crime inside the house as per information given by the accused Bijuliwala Rabha on her surrender before the police station. Corroboration of witnesses as well as supportive evidence of injuries by the medical officer proved that accused Bijuliwala has committed the offense. The prosecution has successfully proved the chain of facts which is inerringly pointed out towards the guilt of the accused. These circumstances, therefore, are of the conclusive nature, and the chain of evidence is complete to accept the reasonable ground for a conclusion consistent with the guilt of the accused, and it is the accused Bijuliwala who only had committed a murder of her husband, Randhan Raba. Another pertinent aspect of the case.
Okay, so we basically relying upon her
Yes.
alleged statement made to the
Yes.
police.
Lordship, there are judgments of the Honorable Supreme Court, Trimukh Maruti, if it is a crime is committed inside the house in the wee hours when there is no possibility of coming any other person. So like family members are the witnesses, but there has to, which leads to, which against the accused person. But here, nothing is there. Trimukh Maruti, I'll- 60. Two 2006, 10 SCC 681.
Vera?
I'll show you Lordship. It's not really- oh, okay, okay, okay. 2006, 10 SCC 681. That's it.
So that is your library.
My library is in the bank. I carry it always. 2006-10. Six, eight, one.
No, this is,
Crime when committed inside the house.
no, but then out here, there's a last seen together theory.
Yes, that is
That
there.
is slightly different. Out here, there's
But
nothing.
yes, that
Uh,
cannot be the sole ground, last in theory. There has to be other
But
circumstances.
here, there is no last seen theory
No,
also.
nothing is-
Then this case.
No,
does
they
not-
have taken a plea that inside the house, 12 o'clock, that factor your.
No, no, but then the thing was that at least, you see, they have taken the plea that they were not in the house at all. So that last scene theory will not be there.
No. And Lordship, there are no other, like, although she has stated that she was not there in the house, but there no, no evidence from her side. Defense witnesses has not been examined. Yes.
Anyway, I think that's.
I don't find anything. I may be wrong, Your Lordship, leave it to Your
That's all I
Lordship.
think.
But one of the witness says that he did not know the whereabouts of the accused from the night till next day morning. And the son says that he was not in the house. So this somehow perhaps corroborates to what she explained in her 313, maybe. And Madam, just two things I forgot to mention, Madam. As regards the use of the GD entry by the trial judge, that perhaps is improper, Madam. There is a Supreme Court decision
Yes.
which is reported in AI 1954 Supreme Court at page 51.
There, 1954 Supreme Court,
Page 51,
51.
Habib Muhammad versus State of Hyderabad, and
Para.
the paragraph is 12.
Yes.
But it's a very long paragraph. The relevant portion your lordship will find at internal page 14. Paragraph 12 and towards the end.
Yes.
Towards the end, just on top of paragraph 13, your lordship will find section 172 provides.
Yes.
That paragraph would be relevant, Madam, because this is only for AD, not for calling for this GD entry and to infer something from there. It is only to aid. So here also, if a lordship see in paragraph 68, the trial judge says.
And anyway, the GD entry has not been exhibited or anything.
No, it is
nothing.
not. That is
And
why
it
I'm
cannot
saying
be
it's
exhibited. also.
correct. That's why I'm saying it's the improper use of the GD entry, because by saying that the chain is completed, that would be wrong. Secondly, my lord, as regards the recovery of the dhow, the discovery of the dhow, one cannot say it is because she pointed out, because if your lordship has seen, PW 12 doesn't mention about the dhow. PW 12 says that when he had gone to her while she was inside the custody, she says, I killed my husband. There is no reference of dhow. It is the police who says that she surrendered and she said, which she explains in her 313 that I said that the dhow was lying next to the body. So independent witness doesn't say, and therefore one cannot say that discovery fact can be proved by taking 27. That also will not come, which the trial judge have ultimately held. That's all, madam. Discovery.
Okay. You've come right on time. If you came a little 5 minutes later on that. Okay, right. That Mr. K. Goswami, learned senior counsel and amicus curiae. Post have also heard Ms. B. Buyan, additional PP. This appeal has been filed against the impugned judgment dated 28/4/2017. Judgment order dated 28/4/2017. Passed by The Court of the Additional Sessions Judge, Golpara, in Sessions Case number 27/2016, by which the appellant has been convicted under Section 302 IPC and sentenced to undergo rigorous imprisonment for life and to pay a fine of ₹1,000 in default, to undergo rigorous imprisonment for 3 months. The case pertains to the no. That's it. The prosecution case in brief is that the informant's brother, Randhan Rava, Rava, was hacked to death by his wife, appellant, with a dowry. In this regard, the informant, PW1, submitted an FIR dated 23/12/2015 before the officer in charge, Bhagwan BAGUAN police station, pursuant to which Bhagwan PS case number 190/2015 under section 302 IPC was registered. The IO thereafter filed a charge sheet having found a prima facie case under section 302 IPC against the appellant, as she had and as the appellant had disclosed to the police that she had killed her husband. Charged under section 302 IPC was framed against the appellant on 18/4/2015 on the ground that he had killed her husband on the night of 21/12/2015. The appellant pleaded not guilty to the charge and claimed trial. During the proceedings before the learned trial court, 13 prosecution witnesses and 1 child witness were examined. After examination of the appellant under section 313 CRPC, the learned trial court came to a finding that the offense of 302 IPC had been proved against the appellant. The appellant was accordingly convicted and sentenced to undergo No, was accordingly was convicted and sentenced by the impugned judgment dated 28/4/2007. Passed in Sessions Case number 27/2006. Full stop. The learned amicus curiae submits that the entire case of the prosecution is on the alleged alleged statement made by the appellant, alleged statement / confession made by the appellant to the police that she had killed her husband with a dao. With dao. Also. He submits that the evidence adduced by the witnesses would show that none of the civilian witnesses were told about were told by the appellant that she had killed her husband, except for PW number 12, PW 12, who stated in his examination in chief that he had met the appellant in the Bhagwan police station, where she had disclosed to him that she had killed the husband. Further, in his cross-examination, PW 12 had stated that the appellant had disclosed the same in front of the police that she had killed her husband. He submits that any statement or disclosure, disclosure or confession made by any person to the police is not admissible as evidence in terms of section 25 and 26 of the Indian Evidence Act 1872. Full stop. Next para. The learned amicus curiae also submits that though the alleged weapon used in killing the deceased had been seized by the police and sent to the Forensic Science Laboratory, FSL, for examination, the report of the FSL was never made a part of the charge sheet. First up, as such, there was no proof that this dao, which had been seized, was the weapon used for killing the deceased. Also, there was nothing to prove that the appellant had used the set thou. Full stop. Anything else?
And that she was not, there is also nothing on
Acha.
record to show that she was there.
Okay, right. The learned amicus curiae also submits that the explanation given by the appellant in an examination under section 313 CRPC goes to show that the appellant was not in her residence with the deceased on the night of the incident, that is on 21/12/2015. And it was only that the appellant came to know about the fact of her husband's death when she went back to her house at around 8 a.m. 8 a.m.
In the morning.
8 a.m. In the morning of 8 a.m. on 22/12/15. AM is morning anyway. That's all, no?
Yes.
Next para. He accordingly submits that as there was no eyewitnesses to the crime and as the alleged statement / confession made by the appellant to the police is not admissible as evidence, comma. The learned trial court erred in convicting the appellant under section 302 IPC. First up. Next para. Ms. B. Buyan, if I missed out anything, you please tell me.
It's all right. The GD entry was also wrongly, I made that submission.
Okay, you just right. One more thing. Huh? The learned amicus curiae also submits that the reliance of the learned trial court erred in relying upon the GD entry made by the police for the purpose of convicting the appellant as police diaries may aid in inquiry or trial. Full stop. However, the same cannot be used as evidence. I could not make use of the same as evidence. Full stop. In this regard, he has relied upon the judgment of the apex court in the case of Habib Mohammed versus State of Hyderabad, reported in AIR 1954 SC 51. He accordingly praised that the impugned judgment and order should be set aside and the appellant should be acquitted of the charge under section 302 IPC. First up. Ms. S. Buyan, the additional PP, on the other hand, submits. Yes, madam. I'm going to record whatever you say.
Lordship may fairly submit the prosecution could not prove the case beyond reasonable doubt.
Submits that the prosecution submits that the prosecution did not prove the guilt of the accused beyond all reasonable doubt before the learned trial court.
And that
In view of the fact that the alleged admission / confession made by the appellant before the police is hid by
section 25,
section 25 and 26 of the Indian Evidence Act.
apart from that, there is nothing. On the,
So she also submits that apart from the alleged statement made by the appellant to the police, there is nothing to connect the appellant to the crime in question. That's all.
That case first.
Let me see, I might add something for you. Okay, that's right. We have heard the learned counsel for the parties. Huh? Hearing concluded, judgment reserved. Okay.
That decision that my learned senior friend had given may be added for on her behalf.
Which one?
But last
That-
seen theory is not there.
Huh?
That's what she argued, that if it is in the household, then there is obviously one doubt that could be the person staying in the house. She submitted that, so that can be added in her submission. She
Okay,
cited the
right,
decision.
that's right. As the, continue, as she however submits that as the appellant was the wife of the deceased, comma, the couple having lived together, comma, the last seen theory, the last seen together theory can be can be considered. No, they would be attracted, can be attracted to the facts of this case. Can be attracted to the facts of this case.
And there should have been a reasonable, in the event of the matter, there should have been an
And in
explanation.
which case? Comma, a reasonable explanation had to be given by the appellant to disconnect her from the crime in question.
I think it's not.
That 313 is again there.
313, she has taken a plea of alibi. She was not there. So I think it's not.
No,
not
cut
required.
that portion. Okay, so anyway, we'll see.
Right.
Sometimes it is because of the investigation and prosecution, I think, they could have gathered some more
You
evidence.
see, there was no 164 evidence,
Absolutely.
nothing was
That could have
taken, they could
taken-
have done that.
And the forensic report they could have got.
But
least
how,
that-
160, yes, forensic, if there was any fingerprint,
At least it have thrown some light.
luckily for you, the Evidence Act.
26.
Huh? Is there also. Because you see, there can be situations where it's the truth.
Well, that
People
is
do
why-
surrender.
Yes.
People do
Well, that
surrender
is why
before the
it was
police.
Incumbent on the police officer to immediately send her for 164. If that
But
was
then you
taken
see, it
care of-
depends upon where they are posted also,
That is
where the police station.
Gwalpara,
If it's a far-flung area where there are no courts nearby, nothing,
Gwalpara, there is.
There is.
maybe during some festival and all it happened, everything is closed. So, and in the meantime, these accused persons have the luck to think about it. In hindsight, they'll say, no.
There are various factors, your lordship. There might be family relation and lordship. There might be other material reasons. Lordship for certain, like to occupy the land to grab the
because
land.
No doubt, it
Happens,
very
my lord.
suspicious that the child pretends to not know anything. A child of 13 years will know. Will know everything. In fact, the police also. I don't think there's. It could be that what they have stated is the truth, but then the law is such. And then we can't convict on the basis of presumptions and speculations, suspicions. Anyway, so probably you all know how it's going to go, but we have got to give a.
So we don't know, your
Reasoned
lordship may
order.
find something.
So you're an amicus, okay.
Deeply obliged.
Probably you'll not be needing the remuneration.
Everyone needs. Every little bit counts. That's what they say.
Can it be a two? my lord?
Item 4 is the council there.
Nobody is there. It's right
Oh.
here.
Okay, we'll take it up at 2. At 2.
Right.
Here,
Yes.
I don't see her regularly in court,
Okay.
But-
So should we change that?
but then she is otherwise whenever
she
she
came
meets
last
me,
time.
she is like interested to do the matters, but.
Okay, then last time she was here.
Acha, acha.
Okay, item 4, you're right. As the learned amicus is absent, this is a matter for hearing. After we.
Oh, this is CBI matter.
Wait, please. In this case, I'm appearing on behalf of the item number 10.
Item 10.
10. On last occasion, I have filed a Wakalat Nama. I'm newly engaged.
Okay.
May I point out one thing? The appellant is in the behind the bar last 29/8/2005.
Huh?
29/8/2005. I'm behind the bar more than 17 years. The punishment is up to life imprisonment. And I have filed an application for remission for superintendent of jail.
Where is that? That's not part of this case. This part, item number 10.
Item number 10. The appellant is behind the bar of 29/8/2005. And the punishment is up to life imprisonment.
And remission is after how many years?
14 years. Section 433.
So you have filed an application for remission.
Yes, sir. I have filed an application for superintendent of jail.
Where is that? There's nothing.
I have filed.
I filed IA something. Yes, madam. She says that.
CBI matter actually.
Oh.
CBI counsel will come. CBI मैंने कहा है?
Who is the CBI counsel?
Earlier it was Mr. Kayal, perhaps now it's Mr. Chaudhary. CBI?
Manav.
Paranga.
No, Manav.
Manas Haloi. Oh yes, Mr. Manas Haloi. I have his phone number, I'll call him. Please come.
What about item 7, 9, 11? They are all.
I think out of the center. There are total 9 number of cases.
So item 10.
Yes,
He's saying that they have been in jail for 17 years
yes.
and they have submitted an application for remission.
Maybe send to the appropriate government for that, lordship. If they have lordship within the bar for 14 years.
So who will be the appropriate government here?
Beg your pardon, lordship.
Who will be the appropriate government?
States.
State.
हाँ, appropriate government, it is state to the state command center.
May I point out one thing? Lord?
Lordship, perhaps Home Secretary will be the appropriate government.
Home Secretary, Government of Assam.
Assam Lordship.
But where is your remission, your application?
It is in the office of the Court of Additional District Judge number 1, Lordship. Landed District Judge number 1. I have filed an application for superintendent of jail, Lordship. Is in behind the bar, no family members is in the Guwahati.
Lordship, may I pray for Lordship to kindly furnish a copy to us so that we can have the instruction.
You give the copy of the order.
We have not.
And you were arrested when? 2005?
2005, 29/8/2005.
29/8/2005. And you have
Languaging
language since then.
since then. Lordship. That is available in page number 59 of my appeal memo. In the judgment. Lordship.
This is the order.
Order. What application to jail officer?
Huh?
He is the family member, he is located. Okay, yeah.
But why did you submit your application to the Sessions Court?
For for taking the opinion of the trial court. Lordship. It is necessary for the taking the necessary.
Under which
opinion.
section?
Section 433, Lordship. Of
433.
Of CRPC. Lordship.
Yes.
Four 432 is necessary. Lordship. 433. May I read it?
Yes.
Power to commit sentence. The appropriate government may, without the consent of the person sentenced, commute A. Sentence of death for any other punishment provided by the Indian Penal Code. B. The sentence of imprisonment for life or imprisonment for a term not exceeding 14 years of or fine. C. A sentence of rigorous imprisonment for simple imprisonment for any term to which that person might have been sentenced for or fined. Lordship.
This for commutation. Is commutation and remission the same?
Yes, Lordship.
Ah,
As per my limited understanding, it is same. Lordship.
Then what does 432 say?
432 Lordship, power to suspend and remit sentence. Lordship.
It says remit.
Yes, Lordship.
433 says what?
430 say commit sentence. Lordship.
Commute.
Commit and 433 restriction on powers of remission or commutation in certain cases. Lordship.
Restriction has been imposed, Lordship, on the appropriate government.
433 A. Lordship.
433A.
Yes, sir.
So, Mr. Counsel, remission is under 432,
Two, yes,
not 433.
yes, sir. Sorry.
And commutation is under 433.
Yes.
So now you are asking for remission.
Yes, sir.
So under 432.
432.
So the court which convicted
Yes,
you,
sir.
that court, the decision will be taken, correct?
Request the opinion. Lord.
Yeah, the opinion of that court will be taken.
Yes, sir.
So now that court is now asking for some information.
Yes, sir.
So why? So
But the original record is in the High Court, Lord.
So this order was passed on 11 January 23.
Yes, Lord.
Now 2 months have passed. Now what has happened?
Lordship, 2 months is already lapsed.
Then what has happened?
Opinion.
What has
The
happened?
opinion
What
has
is
been
the,
given.
what has the court done? No idea.
No idea, Lord. I am nearly engaged, Lord. I have to take it.
So can you obtain information? Why don't you ask the court yourself? You had gone to the court.
Yes, sir. I have to take instruction, Lord.
You please instruct.
Yes, sir. On the line of time.
Okay, right. Correct, Mister. In item 10,
Yes, sir.
name.
P. Dr. Lord, sir.
Your name is not
No,
here.
no, we have filed Okalatama last day, Lord. Yesterday. We have filed Okalatama yesterday, Lord.
Okay, Mister
P. Dr. Lord.
P. Datta.
Yes, Lord.
Mr. P. Datta submits that he has filed Wakalatnama for representing the appellant. He also submits that an application for remission of his sentence has been sent to the sent to the additional court of the additional sessions
The
judge
number 1.
Kamrup Metro. In as much as the appellant has been in jail custody for more than 17 years, since 29/8/2005. Next para. He submits that despite the Court of the Additional Sessions Judge number 1 Kamrup Metro having asked the Superintendent of Central Jail Guwahati to furnish information regarding the date of conviction of the applicants and the details about the status of the appeals in connection with Sessions Case number 227(K/2016. Wide order dated 11/1/2023. No further action has been taken by the Learned Trial Court for remission of the sentence. Mr. M. Haloy, Learned Standing Counsel, Learned Public Prosecutor,
Special public prosecutor.
Learned Special Public Prosecutor for the CBI submits that he will obtain instructions. List the matter when?
After 2 weeks.
List the matter on 3/4. Obliquely. Either matter 7, 9, and 10. Same thing. Who is same? All are same? No.
No, different advocate appears.
Different.
So in those matters, you just say no one appears for the appellants. List the matter. In that 7, 9, and 11. Okay, no one appears for the appellants. Write the appeal numbers. Okay, no one appears for the appellants. List the matter on 3/4.
Item number 10, we have to receive the paper book. The action is
Paper book, Lordship, I have also not received the paper.
Paper book has not been made also.
paper book already made. Lord.
Has it been made? I don't think.
In item number 7, so is the
Where is the order? Is there order for preparation of paper book?
No.
So, paper book has not been prepared. Let it be prepared.
paper book already, one of the council has received. Lord. Paper book already
Has
prepared.
paper book been given in other cases? Just see in other cases.
Order has been passed in the year 2016.
So it's been-
Let me please, Lordship, my lord. Oh, this matter, yes, sir. For item number 9, my lord, Mr. Pallab Kotiki will.
Huh?
For item number 9, my lord, this is the same group, my lord. Item number 9, my lord.
Yes, so what about it?
Yes, my lord, here in this, in item number 9, my lord, item number 9 and this item number, joint paper book was given, my lord. Actually, extra paper book was not given for this item number. Paper book also have been prepared.
Joint, it is against the impugned order is the same.
Yes, same.
Then
evidence.
what do you mean joint or not joint? The one paper book will
Yes, yes,
will
yes.
suffice for all the cases. Then a paper book has been made. Huh? No, this is not paper book. This is not paper book. That's right. No paper book at all. No. Okay, that's right. Registry to prepare the paper book. LCR has arrived or not?
Also has been arrived.
But wait a minute. Give me item 7. Item 7 has a paper book.
Yes, sir. I think item number 7 it is shown as PB, paper book.
Don't say that. You see in the clause list, it is with PB, it is written with PB.
In item number 10, Lordship, as per information, they have received the paper book.
In item 7, they have written with PB.
Yes.
So not the right. The Mr. S. Ahmed, no, your name.
P. Dr. Lordship.
Mr. P. Datta submits that he has not received a copy of the paper book. Full stop. The cause list to criminal, the cause list reflects that paper book has been prepared in connection with Criminal Appeal 95/2017. Full stop. As Criminal Appeal number 95/17, 245/16, 266/16, 50/17 are pertain to the same impugned judgment and order, the paper book made in Criminal Appeal 95/2017 can be used in the other appeals. Accordingly, registry to furnish copy of the paper book in Criminal Appeal 95/2017 to Mr. P. Datta, Learned Counsel for the appellant in Criminal Appeal number 266/2017.
Lordship, may I pay for the paper book also?
Huh?
We have also been not supplied to the paper book.
Have you paid cost? Who's going to pay all this cost? You pay cost for the paper book.
Yes, paper book.
All right, on payment of cost, on payment of cost. For the paper. Otherwise, why should the High Court pay everything? Your appeal. It says 266/16, 266/16. Mr. M. Haloy, Learned Special Prosecutor, CBI, should also be furnished a copy of the paper.
made previous. It is a case under section 302 of the IPC matter.
Huh?
302.
302.
Yes. Because I have to take also through right from the FIR.
Any eyewitnesses?
Yes, there are. There are no idea, direct circumstances. Now we'll also kindly come to FIR. This page 4, my lord, of the paper book. Date is 26/11/2012, my lord. Also kindly note the date. Most especially, I beg to submit that my uncle Sri Hagen Burman, aged 43 years, son of late Jogendra Burman of village so Assam, is an employee of Assam Sagar Security Secretary, Kishan Basti, Guwahati. At about 6:30 p.m. on 25/11/2012, while my uncle Sri Hagen Burman was on duty, at Tel office, first floor, Monal Tower under dispute PS. Sri Anurag Goswami, who was a security guard earlier, along with another person, you will also kindly note that another person assaulted him with a steel strip and other sharp weapons inside the said office, thereby injured him grievously in various parts of his body. Immediately, my uncle was admitted to the GMCS with the help of 108 service, and at about 6 a.m. today, on 26 Monday, the doctor in Senzo declared him dead. I therefore inform you of the incident and request you to Senzo. The incident was of 25th of November in the evening at 6:30 in Bispur. There is near Ganesh Guri, my lord. And the FIR was filed from the place of occurrence to the Thana is about 1 kilometer only. The less than 1 kilometer. Next day, at about 11. So there was some delay in filing of the FIR, and the case was registered under section 448 because 2 persons involved.
Where is the delay? He died on 26, the FIR filed on 26. Where is the delay?
No, he died on in the evening of 26.
He died on 26.
No.
Yeah.
It's for the FIR.
The injury is mentioned, so it is part of the volume. My uncle was admitted to the GMCS with the help of Suncho, and at about 6 a.m. today, in the morning, he died.
Yeah,
But
6
instead
a.m.
of grievous, No. Still, you are since grievous injured, that 326 would have been there. If I should have filed that very death, he might not have died.
What do you mean he might not have died?
Yes.
The doctors declared him dead. What do you
No,
mean he might not have died?
I am coming to the evidence.
Okay.
Evidence I will to check through through all the evidence.
Yes.
Because in the criminal case,
Yes.
my duty as a defense lawyer is to infuse.
No, I'm not saying that. I'm just reading the FIR.
Yes.
As per the FIR, I'm not going to others. Only as per the FIR,
Yes.
it says the doctor has declared him dead. So
And-
as per this
and
FIR, he
filed
is dead.
it about 11 years. Anyway, my lord, but the injury and the incident took place earlier night, about 18 hours ago, just near. That incident was not reported to police. Anyway, then I'll also want to come to Sarsi. 2 persons of Sarsi. This Anurag Goswami I am appearing for, and Bimal Bania.
They are appearing for both.
Hello?
They are appearing for both.
Yes.
Bimal Punia was acquitted.
One was acquitted.
One of them.
Number 2 was acquitted. Then, my lord, now you also kindly come to PW1.
There.
He is not an eyewitness. I knew the deceased, Khagan Burman. He was working as a security guard in Sonso. I know the accused Anurag Goswami, who is standing on the dock of the court. The other accused is not known to me. Specifically, there are 2 persons who allegedly killed him. The occurrence took place about so in the month of November at Monal Tower, situated. At the relevant time, I was at home at Bhetapara, situated at a distance of about 4 kilometers. On the day of occurrence, around 7 p.m., I received a telephone call from one Nath and informed me that Khagan Burman, security guard of so was assaulted by some unknown person. So let me kindly mention, some unknown person. That is important for me. Whether this person was already there or not, some unknown persons and so was called and shifted him to so. During the period, I was working as so manager commercial so. Then on the day received the information, I went to Manal Tower. Police arrived at the place of occurrence and launched investigation into the incident. That was after he was shifted to GMC. I noticed blood stains on the floor of the Sonso. Police seized blood-stained cloth and other articles found in the place of occurrence. Exhibit 1 is the seizure memo and Exhibit 1 is my signature. I inquired into the incident, but nobody disclosed the details of the incident to me. Immediately after the incident, he goes. 6:30
So he's not relevant.
No, it is relevant. It is relevant in criminal case, my lord.
What?
Because one Nath informed him. So, but he say he got the telephone from that place that one Nath informed that so and so is assaulted. He rushes to the place, and but there he says nobody told me about the incident. How is it? Then how did he get the information? Because in a criminal case, my lord,
He said the details, Mr. Counsel, he said the details of the incident. You see, somebody can say that, there's been an accident there somewhere. You go to that place and they don't tell you the details, like what happened, was he bitten by a cow or bitten by a dog or bitten by some animal or hit by a car. So an accident can mean anything. So you cannot, this is only talk about details. The details of the incident was not told to him, that's all.
because it is in the
Neither
mind.
here nor there.
Because he is working in an institution. There is other employees also.
Okay, next.
There, my lord, in this is informant. Pillar 2. The deceased Khagan Burman was my cousin, brother. I know the accused Anurag Goswami, who is standing on the dock of the court. The other accused is not known to me. That means there are two accused, my lord. You also kindly note that. Who hit? Whose blow was that? Who killed him? Who killed him? You see, if there is confusion in determining if the police investigation is perfunctory.
Let us read the evidence, then you can give your submissions later.
No. Each my lord, you can say I have to go and explain it because again coming back will be double over here. What? So the occurrence took place at a so that the deceased was working in a so. At that time, I was at the school hospital. I received the telephone call from my cousin, brother Nilakanta Burman. Nilakanta informed me that my deceased cousin brother was assaulted by the accused Anurag Goswami and Bimal Bania. A specific statement, my lord. And thereafter, he was hospitalized at GMCS. He was admitted. On receipt of the above information, I rushed to GMCS. In the hospital, I found my cousin brother undergoing treatment in the emergency ward. I have seen him bleeding condition from his head. The deceased received 52 stitches. On my inquiry, the deceased in his injured condition told me that Anurag Burman, who came to so officer to so or attempted to commit theft of computer set, but the deceased resisted him and the thereby
Time
he was
declaration. This is the time declaration.
yes, and was assaulted by stick plate and empty bottle wine bottle. But it is not seized. Empty bottle wine is not there. Two accused person not dying. The deceased told me that The accused Bimal Bania assaulted him with empty wine bottle. Excuse me. Bimal Bania is there, who hit him with the empty wine bottle, and that was the grievous injury, and that was the fatal injury. I noticed bleeding injury on the shoulder so, and this is till about 2:30 a.m. Following day, he died on Tuesday at about 3:45 a.m. At that time, I was at home. This is at Krishnanagar, Sanmari. I received the information in that this is accused succumbed to his injury. I rushed to the GMCS. Again, I went to dispute PS and filed an FIR in connection with the incident. Exhibit 3 is my FIR. Exhibit 3 is the printed form of the FIR. After filing FIR, police went to the GMCS and held inquest on the dead body of the in presence of the executive magistrate. Exhibit 4 is the inquest report. The executive magistrate prepared the inquest report in my presence. While Mr. Rajwa reported the incident over phone to the district PS, and accordingly 108 ambulance shifted him from the place of occurrence to GMCS. In the cross, I came to know about the incident in detail from the deceased when he was in injured condition. It is a fact that I did not mention the name of the accused Bimal Bania in my written FIR Exhibit 2. It is a fact that I did not mention the name of accused Bimal Bania in my FIR Exhibit 2. He didn't mention it, but in the evidence he's saying. At the time of narrating the detail about the incident by the deceased, myself, 2 private security in charges, 2 brothers-in-laws of my elder brother, namely Sri Champa Majumdar, and Sri Puna Majumdar, my cousin's brother, Sri Hitesh Bharat, and 2 police personnel were present. It is a fact that in my FIR and statement given before the police, I did not state that I came to know about the incident from the deceased in his injured condition. This you also can see. Because he didn't mention to the police what he was alleged to have heard from the deceased. In 167 statement, he might not have said. Because he says, it is a fact that in my FIR and statement given before the police, I did not state that I came to know about the incident from the deceased in his injured condition at GMCS. So what is come to be, maybe come to be, my dying regression is demolished here. When somebody tells me in injured condition, and I give statement to the police immediately thereafter, I must say that yes, he told me so and so. What is that? It is very perfunctorily conducted investigation. I will also seek. I file an FIR on so and so following day.
Is there any citation in this regard?
The citation I will come, my lord. Citation to the legal point I will show on
No,
the
because
other
then
ground.
again we'll have to go back to this. Now do you have with regard to this point?
My lord, I am coming. Because police has also said, he has also noted the dying regression. So if there is a contradiction, what is my duty? My lord, just to bring doubt to your lordship's mind that there is benefit of doubt, it will come. So if he says in the court, after a few days or few months, that he said so before me, it may be afterthought also. But immediately before the police, just after that is said.
So what happens in this situation? What does the Supreme Court say in this situation?
The man may be in tension or with sort of shock, is true. But he should have said something because he gave the statement before the police.
No, since it has not been said by him to the police, what is the consequence of the same?
Consequence is that, my lord,
Is there any citation that you have got with this on this issue?
Yes. I'll come to that, my lord. because it will take
No, do
time.
you have, I'm just asking you, you come to
Yeah,
that,
yeah, yeah.
I know, but then do
Today I
you
have
have,
not brought one.
you have not brought.
Now, my lord, what I am to do, my lord?
No, I understand
Yes,
what you're trying to say. You're trying to say is that since now in the evidence, he has stated that there was a dying declaration, he should have mentioned this at the time of 161.
Yes,
And so now he cannot improve upon his statement.
Yes.
That's what you're trying to say.
yes.
Now, my question to you is, okay, accepted, but is there any decision supporting your proposition made by the Supreme Court?
Then I look.
That aspect of it,
Yes, that
nothing
time.
else.
Because,
I'm not saying what you're saying is wrong.
yes,
I just want some citations
yes.
in support of your submission.
And my lord, your lordship, because your law, High Court itself, your lordship is independent body. Always there is, may not be any decision on this
And it
line.
is there in
Yeah.
161. I have just checked out.
Ah.
It is there
But
about this,
sorry?
that the injured has stated before him, the dying declaration.
no, I'm not on that.
Yes. That the improvement part,
Maybe
yes, yes,
161.
yes.
Supposing it was not there, then
Yes.
what happens?
It will be improvement. It's for the first time in the court.
Then it'll be an improvement. And what happens then? What is the? How much weight do we give to an improved statement?
Will not give much weight, then it should also come out from the mouth of the IO also. And other evidences if you could prove.
No. So, is there any citations in this regard?
Yes. I'll.
What happens
Yes,
if there is an improvement?
yes.
What is the consequence of it?
Then
Anyway.
my lord, if there is improvement, subsequently, maybe through subtle, through light, my lord, so some sort of doubt on that.
On the credibility of
Yes,
that
yes,
witness.
yes. There is, what is the criminal law says? What is beyond reasonable doubt? Full truth. If he is stated before the police, then he should have stood here also, but he is before the court. Because what is reliable is the statement before the court. 161 is hardly any of credibility, my lord, unless it is same is said in the court also. Then my lord come, I filed the FIR. It is not a fact that since the disease in his injured condition was admitted in the emergency ward, nobody was allowed to talk to him. It is not a fact that the deceased was not in a sound physical or mental condition to speak about against him. Then in the cross examination, it is by Vimal Panya. It is a fact that in my FIR and statement given before the police, I did not state that initially I came to know about the incident for Nilakanta Burman. And he told me that Khagen Burman was assaulted by accused on the Goswami and Bimal Bania. And in consequence, he was immediate to treatment and thereupon I rushed to the GMCS. It is not a fact that I visited the GMCS after death of this so. It is not a fact. Then it is a fact that I did not state in my FIR and statement given before the police that the accused Vimal Bania assaulted the deceased by the empty wine bottle. But in the dying declaration, he said that the deceased told that empty wine bottle was used to
Bimal Bonia.
Bimal Bania, yes. But he didn't establish before the statement the police, in the FIR of the police. Very interesting witness. It is not a fact that I did not state in my FIR instead given before the police that I noticed bleeding injury on the so 52 instances. But 52 instances are not there. I go to the mallet inquest as well as the postmortem report. It is not a fact that the accused Bimal Bania was not involved in the incident. Now he repeats.
Lordship, I have found one judgment, 2005, 59 SCC 588. Contradiction by previous statement made to police. How far his testimony is believable. Neither examination of the witness concerned and investigation officer concerned, and to confront with
Controverted, my lord, by the defense, 161.
18, 19 and 20.
What is the citation?
2015, my diary says I have to check up, 2015, 9 SCC 588. VK Mishra and another versus State of Uttarakhand.
Paragraphs?
Para 14 to 16, 17 and 20, 18, 19 also, my.
Okay, then.
The 161 statement can be used by defense lawyer to controvert his statement in essential, but not by the prosecution. Now, my lord, lastly, it is not a fact that I accuse Vimal Banyo was not involved in the incident. If two persons are involved, who is the primary accused? Whose blow was the fatal? That is to determine. But Vimal Banyo was later acquitted because of the very, like I said, this is a way of investigation. Then, my lord, witness number, this is not very.
Not important.
I simply said, I do not know the accused person who are seen in the incident.
He doesn't know anything.
He doesn't know anything. Then thereafter, and then he said thereafter I went to the GMCS Bhangar and I found that this is under treatment. First exam is declined because there is nothing. Then FSL report, my lord. This is important. My lord, this is witness number 4, schedule 4.
Yes.
I have been working as a fingerprint expert in State Fingerprint Bureau, CID, Assam Urban so. Second paragraph. On examination of the specimen fingerprint of the accused under Goswami in relation to the fingerprint specimen which I collected from the place of occurrence, I found both the specimen fingerprint were identified in 14 characters of the culprit. Exhibit 5 is my report, then my lord, exhibit 7 is the report. In the cross-examination by Bimal Bania, declined. Cross-examination by my client under Goswami. I reached the place of occurrence, when I reached the place of occurrence, I found some employees of the Estel company and police. So the FIR, my lord, who the first information is nobody told me anything about. That's false because there are many people in the tower. Then, my lord, the Susan fingerprints of the accused on the Goswami were formally furnished to me by the police in the Sur. Then I cannot say who were the person at the place of when the fingerprints were obtained. So he doesn't know. Now, my lord, your lordship will come to again his statement by the FSL expert. Only when two persons are involved, and witnesses also say two persons, and so-called dying declaration also say two persons. Two persons, Bimal Bania and under Goswami. My lord, the police does not send the specimen fingerprints specimen of the Bimal Bania. So he was left out. Gradually, he was left out. Because witnesses say, so if the dying is even trusted 25%, 10%, then also he said that he was hit by empty wine bottle, but hard material. But his fingerprints were not sent. Why? That creates a doubt, my lord, that there was an attempt to save the man accused who hit him with wine bottle and condone him his guilt and punish this person. This is a big question, my lord. You will finally note. Then medical officer's report, my lord. Medical report. Schedule 5. On that day, I, along with the Dr. Nayan Kumar Das, demonstrator, Department of Forensic Medicine, performed summary report examination on the dead body of the Khagan Burman aged about 43 years, son of so and so, under TUPS, so and so. External appearance, male body, it is not important, but injuries, stitch wound injuries, 3 cm opposed with the single stitch present over the left sensor. Then number 2, 4 cm injury. There are altogether, my lord, 18 injuries. One is contusion, injury number 1, but stitches are not 52. As the witnesses said, 52 stitches he has seen. 18 injury by one person only. And one possibility, my lord, whether 18 injuries, he is also my lord, security guard. Suppose I am alone, I am also security guard. Both are of equal strength. I hit him continuously. He doesn't protest. He lies. Whether that is possible. There must be 2 persons. Then only my 18 injuries can be caused, my lord, simultaneously, in one go, in one blow. But here, my lord, nothing, no explanation there. Then 52 stitches, how the witnesses seen, that is not known. Opinion is same, my lord, that death was due to emergent shock. In the cross examination, page 22, what the doctor said.
No, you see, stitches, 52 doesn't mean that in one gash, there has to be only one stitch. There can be 5, 10 stitches in one
Yes,
gash
yes.
also.
But there is no explanation. What he says is not explained by the even by the police
Anyway,
officer.
the fact remains that there were injuries.
There were injuries.
This
But
is
who
not,
caused? My lord, fact demand that who caused the injuries?
that is a different thing.
Because that is crucial thing, not different, my lord. This is a crucial thing. If the 2 persons involved, who caused the injury? There will be exclusive finding in the investigation and by the court trying the. Then next page, my page 22. If the injuries were treated at the earliest, there was possibility of saving the life of the deceased. The doctor said, my lord, otherwise the injury is not fatal as such. That will be instantaneous death. But there was some negligence on the part of the either by the police or the persons who took him to the hospital. There was a delay perhaps, for which he didn't get timely treatment. Otherwise, it would be safe. It was 6 is not important, my lord. So I'm skipping over. It doesn't mention. EM report is 18 injuries that I have already shown, my lord. PW7, PW10, my lord. Sorry, IO, PW8. This is important. PW8.
Yes. PW8 also, he's only the one who submitted the charge sheet, that's all.
No, but
Recorded a dying declaration.
Huh?
PW8 recorded a dying declaration.
no, there is another officer. My name is Dimbesha Thakuria.
PW8 is the person, is the officer who submitted the charge sheet, that's all.
Yes,
Nothing
yes,
else.
yes. But he said, I after going through the case diary prepared by my predecessor, I found that the investigation had.
He did not do anything, he did
No.
not do anything, just
So-
submitted the
I
investigation.
collected the fingerprints report and accused from the so. Therefore, I submitted a charge sheet. That's all. Against the accused Vimal Bania and Anand Goswami. He submits charge sheet against 2. Throughout the case procedure, there are 2 persons involved. Police investigation also detailed that. Then, my lord, in the cross, he said it is. I didn't visit the place of occurrence. I didn't censor because he is not supposed to go. Then my PW9, he is also IO.
He recorded the statement.
Yes, he says. He says. It might not have recorded, but he says he recorded. Because I saw from the provision of law and also his statement. On 25.
But it was not taken in separation.
You are checking it was case there was not paginated. That is a fatal.
Exhibit 13.
Yes. Now let me first read his statement, my lord. On that day, on receipt of the verbal information, I visited the place of occurrence. Then I had seen a person with bleeding injury, and there in the first floor. Thereafter, I recorded the statement of the injured person, namely Bhagan Burman. At the time, the OC disposition also arrived. The treatment of the statement of the victim was recorded at the place of occurrence, but I was not taken. It was taken. It was not taken in the subsheet, and it was under my handwriting. I will read the statement of the Sri Bhagan Burman injured recorded by me under objection. It was recorded. Then cross examination. Exam 13 was recorded by me, but till that the case was not registered. I received the information at 7 p.m. and so on. At the time in hospital, the disease was in sense. Now he says, but that at the time of hospital, but he says he recorded the statement in the place of occurrence. Then at the time, that means at the time of recording his statement, the disease was in sense. It was in hospital. Where he recorded, whether in the place of occurrence or in the hospital. At that time, means at the time when he recorded the statement, the disease was in a sense in the hospital. Then cross-examination the under Goswami. It is not a fact that the case diary manipulated documents. In the suggestion, you also can note that we have already suggested him that he would manipulate the case diary to protect vulnerability and trap me. It is not a fact that I conducted the investigation in perfunctory manner. There's a put to his mouth. Then, PW 9. This is also another, there are two PWs, 9. I read just now, he's a PW 9. Now I am reading PW 9. Is 29, he's on 9. Mukesh Mandal. SI Police. Now this PW 9 who claims
Kokendra Mandal.
Yes. Kokendra Mandal, name Mukandra Mandal. Then the earlier one is PW 9, Tandi Sinha. There are two. Once we will file the charge sheet, these two are the investigating officers. Tandi Sinha, he says he recorded. Then my lord, now you have to come to his statement. On 25 April 2012, I was working as the attached officer at Dispute PS. On that day, I was on mobile patrolling duty from 2 p.m. At about 6:30 p.m., I was informed by the OC Dispute PS or phone that at Mona Tower, first floor, STL office, some miscreants, you also kindly note that some miscreants dispatched criminally and by assaulting the security guard on duty, they had attempted to take away the laptop from the said office. Hearing the same, I immediately I proceeded to the Monal Tower under the jurisdiction of Dispute PS. Before me, Papa vehicle number 3 under in charge of the SI, Sandeep Singh, arrived at the arrived there. Before me, DSP Supradik Lal Barua and OC Biren Dek also arrived there. On going there, I found that different articles in the said office of Tower are lying scattered on the floor with blood stains. I also could come to know that under the instruction of DSP Lal Barua and OC Biren Deka, the victim security guard was forwarded to GMCS for medical treatment. Blood stains were everywhere in the floor. Immediately after my arrival, the CID officer also arrived there with the photographers. They started inspecting the PO in my presence. After that, CID inspector, I seized the articles with blood stains in presence of the witnesses. Exhibit 1 is the seizure list. Seizure list will be important. Mala, I take a lordships to page 69 later on. Seizure list. And exhibit 1 will be my signature. Metal exhibit 1 is the false floor ceiling stand. Exhibit 2 is the 2 and exhibit 3 are the steel bars of false ceiling. Exhibit material exhibit 4 is the security uniform with the blank. So, my lord, there are 3 items which could be used for hitting a person. Metal exhibit 1, 2, and 3 uniform with black color and whistle cord. I also prepared a sketch map of the exhibit 14 in the sketch map, and exhibit 14.1 is my signature. The CID personnel during the PO visit, place of visit also took the photographs of the PO. They also took fingerprints, etc. from the PO. I did not go to the GMCS because SI Tanvi Singh was sent there. On the day, I could not examine any witness because most of the witnesses left along with the victim. On 26 September 2012, the FIR was lodged by Manmohan Burman, and after received the same, the FIR was registered by the OC. Exhibit 2 is the FIR. I was formally interested to do the investigation after filing of the FIR. On the next morning, 2 witnesses, Devajit Raskwa and Kumod Bharali, appeared at the police station, and I recorded their statements. After the registration of the FIR, I recorded the statement of the complainant. Before filing of the FIR, the investigation was initiated on the basis of the GD entry number so and so data so and so. GD entry was given at 7 p.m. In the FIR, the name of the unknown person was disclosed at the prime accused. It was also alleged that Anurag was Goswami along with another miscreant. Let's kindly note that Anurag Goswami along with another miscreant came to the office and demanded the laptop, and the security guard objected. He was assaulted. From examination of the informant and other 2 witnesses also, the name of Anurag Pradhan came. Further, the other 2 witnesses also named Bimal Bania. So there are 2 persons, my lord. Bimal Bania. The name of Anurag Goswami was also disclosed by the victim Khagan Burman in his dying declaration of recorded by SI Tanvi Singh. On the basis of the message, Naranapur PS under North Lakhimpur district arrested the accused Anurag Goswami. From the said PS, information was given to Bimal Bania to appear before the PS. Receiving the information, the accused Bimal Bania directly came to Guwahati and surrendered before the district PS. I arrested Bimal Bania at the district PS. Anurag Goswami was also brought from Naranapur PS. I interrogated them and recorded their statements. I arrested them and forwarded them to the court. From the court, they were brought back to police custody for 3 days. During their police custody period, the fingerprints experts from CID department to fingerprints of both the accused. My lord, this is very important. The fingerprints of was taken by the fingerprint expert of both the accused, but only one report has come. What about that? During the place of custody, period of custody, the fingerprint experts from CID department took fingerprints of both the accused for comparison with the earlier fingerprints they had collected during the visit of place of occurrence. Victim Khagan Burman had expired on so and so so. The inquest was done at GMCS by an executive magistrate so and so. and the investigation inquest report. I issued command certificate. Exhibit 9 is the said command certificate and exhibit so. It's you will also may skip. So my lord, fingerprints were taken out both the accused persons. Why fingerprints are expert opined only on one under Goswami matter? This is IO. His statement is the crucial statement in the criminal investigation system matter. It throws doubt why Bimal Bania was sought to be protected. Was he really guilty? So he has to be protected, or some other element played the role, some pressure or something. So I must say that. Then examination correction of Bimal Bania, PW2 Manmohan Bani Burman did not state to me that accused Bimal Bania had assaulted the victim with the empty wine bottle. PW2 Manmohan Burman did not state to him that on going to the hospital, he noticed that the deceased had 52 stitches. He only told me that the deceased had grievous injury. I did not examine any Nilakanta Burman because who was supposed to give the information, who had given Nilakanta Burman, he was not examined. This witness was brought. PW2 did not name Nilakanta Burman as the source of his receiving information about the assault of the deceased and that he had been hospitalized. In the FIR, the name of Bimal Bania was not mentioned. In the FIR 2, there is no mention of that Bimal Bania had assaulted with the empty wine bottle. I did not forward the deceased items for forensic laboratory to ascertain the blood stains. It is not a fact that Bimal Bania was not involved. Bimal Bania was involved, he says, in the case. And due to confirmatory investigation, I added his name with case for my client. Victim Khagan Burman in his dying declaration stated that accused Anwar Goswami had served in the said office as exchange soldier. The dying declaration was in the case diary. I cannot say whether it was submitted before the court or not, along with the charge sheet. It is true that case diary was not paginated. Case diary must be paginated under section 172 of the CRPC and 188, 199, 190, and 190 up to 193 of the police manual. It was not paginated, my lord.
It has to be paginated.
Yes, must compulsory.
As per,
My lord,
as per.
as well 172 section CRPC, 172 1 small a. Then my lord, under the police act, police rules also. On that, my lord, there is a judgment of this court, my lord, by of course by single bench, but all senior advocates were heard on that point. 172 A, my lord. 1A. 1A, 1B.
This is with regard to 161. Wait. Huh? No, where is giving me this? Assam Police Panel. Ajay.
172. Every police officer making an investigation under this chapter shall day by day enter his proceedings in the investigation of the investigation in a diary, setting forth the time at which the information reached him, the time at which he began and closed his investigation, the place or place visited by him, and the statement of the circumstances ascertained through the investigation.
172. The time is referred to.
Then married 1A. The statement of the witnesses regarding during the course of investigation under section 161 shall be inserted in the case diary. The case diary referred to in so shall be a volume duly paginated. On this, my lord, there is one judgment of this court. I'll show you 2012, my lord. And my lord, policeman will. Policeman, my lord. Assam policeman, my lord.
Yes, tell me.
I think that is. Volume 2, my lord. Volume 2, part 5, Roman 5, rule 1.
Page.
Not that will be different, my lord, it might be the same, no?
Yeah.
329.
Yes.
188, my lord, here also it refers to 172 section of the CRPC. Section 170 criminal procedure code prescribes the case diary, the form of case diary are issued in bound book, but here my lord, in Assam is not issued in bound book of 100 forms. Carbon copy shown. Each form has a separate printed number running consecutively that through the book, so that no two forms will bear the same number. Investigating officers will write their case diary on this form, placing one or the two sheets of the carbon paper underneath. That original record, according to the number of the copies required. On the conclusion of the investigation, the sheets of the original diary will be removed from the book and filed together. Every file will be docketed with the number, month, and year of the first information report. The final form submitted and the name of the informant, the accused and the investigating police officer. The order regarding the preservation and destruction of these papers should also be noted. All case diaries will be invariably be regarded as confidential and kept under the lock and key in a secure box until the case to which they are related is finally disposed of by the order of the magistrate or the judge, and an appeal paper has been decided. This is not. Then by 180, 190 also kind. The contents of the case diary. The case diary is the record of which section 167 requires an investigation officer to keep of his proceedings in connection with the investigation of each case. The law requires the officer to show in this diary the time at which the information reached him, the time at which he began and closed his investigation, the place and place visited by him, the statement of the circumstances ascertained through his investigation. Nothing which does not fall under one of these heads need but enter. The first diary, however, should contain the summary of the first information report for the convenience of the superior officer, and the information obtained from the village crime is not important. Then L is going to be 190A. For this procedure to be followed by the investigating officer regarding the value of property is not even. Mainly here, my lord, what I am on was 172 section. The case diary must be paginated, otherwise there is chance of putting in loose sheets afterwards. That's what our High Court said. And the High Court decision, though a single bench decision, my lord, was after hearing the Advocate General of the State, Government of Assam, and also the Minister Nilay Datta, Senior Advocate, then Jati Chaudhary, Senior Advocate, then Ms. Hajika, paragraph 9 or so, 2012 2 GLT page 994. It's a very long judgment, my lord. I am just The facts of the case I need not go into. There date wise party naam whole Kumar. It is I think so motor. So motor by High Court. Actually, Bhakur Islam versus others respondents, but this was so moto taken by the High Court. And law has been laid down by here. Paragraph 9 and 15 will be important. Madam. Page 24. Internal page. The present one is paragraph 9 is also important.
Huh?
Paragraph 9.
Yes.
The present one is a case wherein interim direction for pre-arrest bail was granted in favor of the citizen of this country. Despite the direction, however, there was misconduct on the part of the police officer Maru by detaining him illegally. However, the man was kept detained by the police on one pretext or the other until the time the High Court, as mentioned above, directed the officer in charge of the concerned police station to appear in person along with the prisoner who had been granted interim direction for bail. Rule 190 of the Assam Police Manual requires that in respect of every case which is registered at a police station, the investigating officer is required to be issued a bound book of 100 forms each. Each form has a separate printed number running consecutively throughout the book so that no two forms will bear the same number. Moreover, the Code of Criminal Procedure amended Act of 2008, effective from 31/12/2009, has introduced the following amendments in section 172 CRPC. 1A. The statement of the witnesses recorded during the course of the investigation under section 161 shall be inserted in the case diary. 1B. The diary
Let
report.
us not dwell in that. It's
Hello?
too long, this small
Hello?
issue. That CRPC is already there.
Yes. And while paragraph 9, the guidelines, because after hearing the comments of
Let us
the
go to some other issue.
laws have been let down.
We are wasting time on this issue.
No, man, where the court is found here.
The
Here the-
statutory rule is already there.
No,
Why
rule
do you
is there,
have to
man.
go there? Then
Because why it is
do you
important,
have to go beyond?
I am Mr. Malak, a lot to kindly bear with me, Malak, because the criminal case, murder case, Malak, he is in jail.
Maybe, but then you have got to remember that yours is not the only case in the Guwahati High Court. There are so many other cases.
Already, but in my.
We have already, that point has already been reflected in the statutory, in the CRPC. So that's enough. What more do you want?
The High Court says one more thing I want here. One guilty may be released, shown innocent by later on putting the page there, by not presenting it, or one innocent may be put in jail. So that is what this is the theme of this judgment. However, each case is important for each client and each lawyer, because we have to defend the lawyer.
No, it's
Yes,
not
I
that.
know
You
your
see,
lordships.
you have got, we are not saying that you shouldn't defend. And it's not that we are not giving you time. But the problem is, there are lots of cases that to be decided. And you should not dwell too long on one single point, which is already quite clear.
Yes.
You see, for one thing, you could have taken 2 minutes, you're taking 10 minutes. This aspect has already been decided in that 172 1B.
Yes.
Then what more do you want?
Because not only by
Wasting
citation of
time.
the law, my lord, because I am to also convince your lordships.
No, if we are unconvinced, we'll ask you.
Yes. Now lordship will come to first examination. In page 31. Page 31, my lord.
Yes.
It is true that, as a lordship, my lord,
Yes.
it is true that the case diary was not paginated. It is not a fact that dying declaration was created subsequently to improve the case. Because we are all suggested, madam. It is not a fact that the material exhibits exhibited today are not connected with the commission of the offense. It is not a fact that without any evidence, accused another person was arrested. So, madam, we will also suggest that it was just subsequently improved to improve the case, madam. This it was not taken here, subsequently injected in the case diary. Now, madam, so these are now 313 statement of the accused persons, madam.
Then you've got your defense witness also.
Madam? Yes. One.
Defense witness says nothing much. to
Nothing,
say.
nothing. He doesn't say. Because you are not there. He was in Narayanpur, Malat, 450 kilometers from me. That image says he was in Narayanpur on that day, on 25th night. So there is no possibility of committing the offense here in Guwahati. That much he said. Now, 313 statement of the accused persons. They have already denied.
All denied.
All denied. In certain matters, that will be what they do. Then judgment, my lord. Judgment is primarily based on the dying declaration.
Dying declaration.
Only my lord, on 131 statement, the Honorable Goswami said, my lord, my client said that question number 6, my lord.
His fingerprint might be there because he used to work there.
Yes, he was there, certainly.
That's all.
That's all, yes. So that is not unnecessary, my lord, because you are working there, you might also tell many things, many items. So there is. Then judgment, my lord. हमारा page 41 onwards, 47 onwards. Reason and reason
So
thereof.
basically, dying declaration is the basis for conviction.
Yes.
Correct. That's
Yes.
the only thing.
Yes.
So your case is that there is no question of dying declaration for the simple reason that in the dying declaration, he blames, the deceased has blamed Bimal Bomai
Yes.
and not the present appellant.
Yes.
Number two, the dying declaration was in the CD, which has not been paginated as required under the CRPC.
Yes.
That's all. What more do you want? That's it.
And wine bottle was wine bottle was not exhibited, not brought.
Wine bottle not brought. What about your fingerprint in the wine bottle?
Yes. And the fingerprint of Bimal Burman was not collected.
Was your fingerprint there in the wine bottle?
No.
No.
It was in the diagnosis, it was said that hit by wine bottle by Bimal Burman. That was not collected. Even
Was the wine bottle seized?
no.
Wine bottle not seized.
Not seized. Interesting matter. Police sent the fingerprints of both the accused, but
Was it an empty wine bottle?
empty. Empty. He said empty wine bottle. And that means that must be the fatal malware of wine bottle of the glass.
Wine bottle should break actually.
Yes.
Unless you have hit only once or twice or what. Wine bottle should break.
Break. but there is no evidence on that at all. In the dying list, it was there.
And anything else?
So this was then I guess inquest report and other things are there, madam. But if your lordship is on primarily on that, and if that solves my case, madam, then I may not take a loss.
No, we don't know if it serves their case.
Caesar witness also, madam, this person was not the Caesar witness, madam, in Caesar list also, this Sarath Varman. So these things are there, madam. It was, here they are madam, then if they anything reply, I reply.
Yes, madam. His basic case is that the dying declaration made, which was heard by the PW2, is that Bimal Bomai had hit the deceased, not the present appellant.
But the dying declaration, which was exhibited at exhibit 13, speaks in contrary, the deceased has named both the persons.
In
It's
the
not
dying
that only
declaration.
Bimal Bora was named, although he was acquitted. The name of this one, Anurag Goswami, is also there. Your lordship may kindly have a look, my lord.
Why is Bimal Bomai acquitted?
Lordship,
One year.
Bimal Bora,
Bimal Banya
my lord.
acquitted if he is also named as a assailant.
Lordship, as at page 63, honorable court hold, my lord, held that. Para 46,
Page 63.
my lord. But
Yes.
as can be seen from the testimonies of the prosecution witnesses discussed above, none of the prosecution witnesses has seen the accused Bimal Bonia accompanying the accused Anurag Goswami and assaulting the deceased.
Where are you reading?
Page 63, page para
46.
46.
Okay, but as. Yes.
Lordship. But as can be seen from the testimonies of the prosecution witnesses discussed above, none of the prosecution witnesses has seen the accused Bimal Bonia accompanying the accused Anurag Goswami and assaulting the deceased Khoghan Bormon. Therefore, as there is no evidence to hold that the accused Bimal Bonia was also involved in the commission of the alleged crime, and as the deceased Khoghan Bormon did not mention his name as the other youth who was accompanying the accused Anurag Goswami,
But this is wrong.
it is wrong. It may be wrong.
But this is wrong.
It cannot
You,
be
you
wrong.
come to PW2 at page 10. Page 10, page 11,
Right.
third paragraph.
Yes. On my inquiry, the deceased in his injured condition told me that Anurag Goswami, who came to Estel Private Limited Company office at Manal Tower, attempted to commit theft of computer sets, but the deceased resisted him and thereupon he was assaulted by stick plate and empty bottle of wine. The deceased told me that the accused Bimal Bonia assaulted him with empty wine bottle. So, Lordship, there are two aspects of the matter. The injury sustained by the deceased, which one is fatal? Whether it was the hit given by Bimal Bonia or Anurag Goswami.
So both,
But I
so
think
there were two wine bottles or what? Or they were saying now it's your turn, now it's your turn.
he
They
was
were
a
giving
stick
each
plate
other
and
the.
empty bottle of wine. Yes,
Yeah.
yes,
So if it's empty bottle of wine,
yes.
it appears to be one wine bottle. So were they taking turns,
No, there might be a situation while both of them were holding.
holding and hitting?
Yes.
Okay, you hold this part, I hold this part, and.
No, Lordship, empty bottles of wine maybe they were holding. Both of them were holding. Because he has named Anurag Goswami assaulted by stick plate and empty bottle of wine. Accused Bimal Bonia assaulted by empty wine bottle. There are 80 numbers of injuries.
So, the learned trial court,
Yes.
if it had convicted Anurag so and so with the on the basis of the dying declaration, how could it say that Bimal Bonia was not
Yes,
involved?
I think there's a wrong on the part of the learned trial judge. But in appeal also, your lordship may reappreciate the evidences, my lord, in appellate stage also. And coupled with this portion,
An appeal has been filed by the state against.
no, I had notice has to go to the person who was acquitted. So moto, your lordship may do so. But your
So
lordship,
why should we do so?
on
how can we
the
do?
lordship, there are and has the punishment. Yes. He was acquitted, my lord, but
Can we do it so moto?
the punishment, your lordship, but since he was
With
acquitted,
regard to punishment, maybe. When the minimum has not been given or something like that.
I think, yes. But coupled with that portion, the dying declaration, the forensic expert's opinion is also there. It's there, it's a, lordship.
No,
it
no,
was a-
that is, this is that dying declaration. It's no doubt that that person died due to the wounds that were inflicted upon him. That is not disputed at all. Now, the dying declaration was given to whom?
Yes,
Was given
to
to
the IO.
PW2 and
No,
to the
and it
IO.
was recorded by IO, SI, not SI or police,
PW9.
PW9. But that was not put to him, it was a fatal or whatever was about the mental condition also. And cross-examination is not there.
Was not put to the IO. Because the dying declaration was heard only by two persons. Only by PW2 and the IO. Correct.
Yes. Forensic expert's opinion is also there. Yes.
Uh, we have got some some prior engagements
No.
with them. So okay, we'll list it after.
Day
Day
after,
after,
yes, because
Thursday.
tomorrow I'll be out.
Okay, right. On the prayer of the parties, this is the matter. Day after tomorrow. Then yes.
So,
Next item, my lord, I am for the acquitted person.
Obliged,
This
my lord.
Criminal appeal was filed. Only the other day I received the paper book and government is also there. She says she has not yet been given the paper book.
No, perhaps we have received, our office person has received,
Anyway.
but I don't have it
So
now.
anyway, I have received only that day. I need some time for preparation. Mr. Kotogi appears for the, my lord, appellant victim. We talk to each other, my lord. We both agree, he is not here. We both agree that the matter may be listed after Bihu, my lord,
After Bihu.
Yeah.
Okay.
on 20th.
My lord, if I may pray, my lord, it's a case of 2010, my lord. In fact, I talked to Mr. Kotoki also. If it can be, my lord, during the last week of March, my
I
lord.
have talked to your senior. I have
Yes.
talked to your senior. He agreed.
He also talked to me.
Telephone last night I told him. Perhaps you don't know after Bihu.
Item
Item
For 13.
14.
No,
14.
14. Okay, right. On the prayer of Mr. A.C. Borbora,
And also
learned
sir.
counsel for the
acquitted persons, my opposite parties.
acquitted persons.
Respondent, there are 18 respondents.
Acquitted persons
And
and Ms. L. Jahan and
And
additional
government-
PP. This is the matter. After the Bihu vacation.
Lord, may I fix a date, my lord. April
You write
20.
also Mr.
JC Boraman,
J.C. Bora for the appellants.
lordship.
This is the matter after, and this is the matter when do you want?
28th, my lord.
This is the
27.
matter on 20. 24, huh? 20.
Make it. My lord, item 15.
Item 15,
Item
yes.
15, my lord, if possible on 30, 30th of March.
The POXO matter. some contradictions are there.
Okay. We'll see 2 weeks after the, on the prayer of Mr.
AM Haloi.
K.M. Holloy. Then it comes for the appeal, there's a matter on 30th March.
Much.